dismention item number 29, my lord. Can this matter be taken in next week, my lord? 18 or 19, my lord. We are not interim also, my lord. 29.
Okay, on the prayer of Mr. D. Bora, learned counsel, let the matter be listed on 19th.
18 or 19, my lord?
19th.
19. Deeply obliged.
I beg to mention item number 32, Lordship. Lordship,
Hmm. Yes,
yes, no case diary has come, Lordship. Case diary has not come. Lordship.
Item number
32.
32.
Yes.
32 serious.
Lordship, due to some personal difficulty, Lordship, it may be adjourned. Any date next week, Lordship.
okay, on the prayer, you are Mr.
PK Das, Lordship.
On the prayer of Mr. P.K. Das, let the matter be listed on 19th.
Apply.
May I please, Your Lordship. Your Lordship, I beg to mention item number 39, Your Lordship. Your Lordship, we have some personal difficulties for today, Your Lordship. Can it be fixed on next week, Your Lordship? Any date in the next week? TCR is received, Your Lordship.
39 next week on the prayer of learned counsel.
A date may be fixed, Your Lordship. A date may be fixed on. Nineteenth is possible, Your Lordship.
19th.
I love you.
May I please vote? I beg to mention item number 33. The arguing counsel has put away some difficulties to the matter. May I please vote adjourn the matter for the day.
33.
Please.
Okay.
I'm
The-
P. Bora on behalf of Westport.
On the prayer of MSP P. Bora, the learned counsel, appearing for the petitioner. Let the matter be fixed on. When do you want?
And is it next?
Next week, 18th.
May it please the Lordship. Also, I'm praying for listing of one bail application for withdrawal, Lordship, tomorrow. Bail application for withdrawal.
When?
Day after tomorrow, Lordship.
Day after tomorrow. Tomorrow. Day after tomorrow is
First
Saturday.
Friday.
Next
Tomorrow.
week. Next week.
Friday, Lordship.
Next week, Monday.
Lordship.
Monday.
Like to mention item number 27, Your Lordship. Case there is not the Lordship, I want to enter in Your Lordship.
Item number 27, you write, heard MSG Bora. Case there in the instant cases yet to be received. Let the matter be fixed on
My lord, on 6th.
6th of March.
Lordship, I beg to mention item number 26 for withdrawal.
20?
26, Your Lordship.
Hmm.
For withdrawal, Your Lordship.
How to pronounce it? I say in minutes. Yes, yes,
Item number 26 for withdrawal, Your Lordship.
26. Withdrawal.
Yes, Your Lordship.
Heard Mr. A. Mishra, the learned counsel, appearing for the accused applicant. Also heard Mr. K.K. Parasar, the learned
No, I'm
Oh.
custom.
customs. Oh, and Kakoti, the learned counsel, appearing for the customs department. Mr. submits that he has instructions to withdraw the matter. Prayer is allowed. The matter is dismissed as withdrawn.
Then item number 23,
Hmm.
today's list, more than affidavit regarding objection has been filed by the IO yesterday. That will be called for, my lord.
In 23,
23, regarding objection, my lord.
And Lordship, I am for petitioner. I also filed a reply of additional affidavit and reply, Lordship. That may be called for, Lordship,
And they also filed, my lord.
in connection with item number 23.
but why, I mean, reply and all these things in bail matters?
This case, my lord, NDPS matter, SP, my lord, request us to file an objection.
Okay.
Objection already given.
Hmm.
He want to file an affidavit in format. Yesterday we have filed it. Now they have filed any reply.
Lordship, I beg for listing for admission, Lordship, criminal petition. Next week, any date, Lordship.
Next week, after next week. Next week it will be difficult, lot of matters. on 24th. Criminal revision,
26, on 26 also.
criminal petition for what? Okay, let it be listed in the next week.
26.
Okay, 26th.
Lordship, I beg to mention a bail application, your lordship.
Hmm.
In this case, your lordship, it's a Marpet case, your lordship, basically. One thief was caught
No, ki, what mention? You want to do what?
for listing, your lordship.
Listing when?
Tomorrow, if possible.
Tomorrow, Friday. Okay.
Obliged. And your lordship, another bail application for listing tomorrow.
Tomorrow itself.
Yes, sir.
Okay.
Much obliged.
36, anybody? 36. What's about the time?
On promotion. Wait, please, your lordship. The petitioner is languishing in jail since minor 112, as of now,
Hmm?
1 minor 2026, as of now 43 days.
Hmm.
Page 14 of the FIR here says that, my lord, it is FIR lodged by one, my lord, police personnel saying that, my lord, having received certain information, they intercepted the vehicle on the way and charged the vehicle, and, my lord, found 1.2 mm pistol from one of the lady, my lord.
Hmm.
Further, they say that, my lord, they were preparing to committing dacoity, my lord.
Hmm.
And this is the entire case of the prosecution, my lord. They are preparing to committing dacoity. 1.2 mm pistol were recovered from one lady, my lord.
Hmm. How many people are there?
4 people are there, my lord. One is
Yeah.
arrested, only one before your lordship, my lord. On kindly see page 24.
One is arrested.
No, all are arrested.
All are arrested. You are only for one person.
One, my lord. For example, nothing has been recovered from possession, my lord.
Nothing. The pistol has been recovered.
From one lady.
Oh, correct. I mean, you were in the same group.
Yes, my lord. We actually, my lord, we are returning back after retaining, my lord.
But you wanted 4 rifles to be carried or
No,
pistols to be carried for
no, no,
dacoity.
The 1 after retaining, my lord, New Year party.
Okay, we'll call for the CD. We'll see. I mean, what is there?
Once you kindly see, my lord, page 24.
Please.
Yes, 36 notice, my lord.
No, we'll see the CD. That's why if 36 notice is not complied with, we'll have to see the CD.
Yes, ma'am. Page 24, ma'am. On page 30, section 36 says PPL memorandum of arrest which shall be attested by at least one witness. You also can see the column of the witness. No signature is there.
Mr. Parasar, actually, these police officers should be booked. I mean, it has happened. I mean, DK Basu happens. I mean, way back, and that this is
Now-
a statutory thing.
Critical messages come now, they forgot the table, my lord. But this is 47, 48, now they are complying.
I mean,
Now-
it's 3 things only.
Yes.
47, 48,
Now-
and this memo. I mean, these things they are not doing it.
No,
I mean,
but
the
we have
police
to-
person who is concerned,
My
he
lord,
should be brought on.
my
He should
lord,
be brought in.
we are my lord, repeatedly informing my lord, to DGP, my lord, whenever.
Anyway, we'll call for the CD. We'll heard Mr.
FKR Ahmed, no, my name is the shown in the cost title, my lord.
You are Mr.
FKR Ahmed.
Canon, the learned counsel accused accused applicant, also heard Mr. KK Parasar, the learned APP for the state. This is an application you write. Then the case relates to recovery of 0.22 mm from the possession of a co-traveler. You're traveling in the same vehicle.
Yes.
Co-traveler, co-traveler, namely, no, co-traveler, full stop. All for the CD. Let the matter be listed on
28, 20.
28. Yes.
All right. I can do.
Hmm.
Intermediate quantity lordship.
Hmm?
Intermediate quantity lordship. Petitioner was arrested on 31/12. Today is 43 days lordships.
How much intermediate quantity?
Lordship. 43 days today lordship. And nothing has been recovered from his person lordship. Kindly see page 14 lordship.
Page 14.
14. That is FIR is mentioned lordship. Only one knife and
one mobile phone had been recovered from his possession, Lordship.
How many of you were there?
My Lord.
How many of you were there?
Persons were there, Lordship.
Hmm, hmm.
Case 14, my Lord.
You were traveling together, or what?
No, Lordship. I have been arrested from in front of my house, Lordships.
Hmm.
One knife from the person Dilnur Ali, and one mobile phone so answer number from Dilnur Ali. Lordship. 43 behind the bar, Lordships. And my wife also delivered a child recently in the month of December, Lordships. So I have to look after him, her also, Lordship.
Yes, Mr. Podasar.
My lord, let the short date may be given, my lord, I'll produce the, my lord, CD. my lord.
43 days, Lordships.
During-
Nothing has been got from his possession,
Yes,
Lordship.
person.
Only one knife, one mobile phone, Lordships. He is a local person, Lordship. Any condition, Lordships, my Lord.
My lord, page 14, para 1, 2, 3, 3rd. During preliminary inquiry, it is also learned that both the accused persons were habitual drug peddlers. Dinur Ali was arrested and forwarded in connection with North Gauhati PS case number so and so also. But alia commercial.
No. 21A, Lordships.
21A. So
It is 21A, Lordships.
so maybe my lord, they are drug peddlers, my lord. So my lord, at this
But local one, kindly see from where he is arrested. He is arrested from the Agyaturi, and his house also from the Agyaturi, Lordship. And only one knife in front of my house, Lord, he was arrested, Lordships. So, my Lord, nothing will happen. 43 days behind the bar, police got the sufficient time, Lordships. And the learned session judge rejected my prayer earlier, my Lord, as because it's the next stage of the investigation. Today is 43 days, Lordships.
yes, my lord,
That may be considered, Lordships, on any condition, Lordships.
in the FIR itself, my lord, reflects that other case also
Maybe that is 21A, Lordship.
maybe 21 ml, but NDPS.
Yes, he consumed earlier, Lordship. Thereafter, he went to the rehabilitation center, Lordships. That is admitted, Lordships. And now he is already avoided all.
Hazu, my lord, I will produce, my lord, on 19.
43 days. 43 days, sir.
50 days upon.
Why not?
Then it will be 50 days, my lord, maximum, my lord.
Well, kindly 43 days, Lordship. That is what might come to some.
You bring it on 17th.
My lord.
Hmm?
My lord.
17th, he'll bring the case. We'll consider on 17th. Heard Mr. So-and-so, the learned counsel appearing for the accused opinion. Also heard Mr. Podasar. Then write, this is an application that the case, the allegation relates to recovery of
One night,
one knife,
one mobile.
one knife and one mobile phone from the possession of the alleged proposition of the accused applicant. However, he has been implicated by one co-accused as a drug peddler. Call for the CD. Let the matter be listed on 17th.
I want. Okay.
Is a motion. Bail application where the accused petitioner is arrested on 24/09/2025 and he has been behind the bars for 141 days, Your Lordship. This case is registered under Section 6 of the POCSO Act. And since this is a charge sheet of matter, Your Lordship, TCR has to be called for.
Notice and TCR, my lord.
This has to be.
Heard by Ms. So-and-so, the learned counsel appearing for the accused applicant. Also heard Mr. K.K. Parasar, learned APP for the state. This is an application, you write. The allegation relates to rape of allegation relates to sexual exploitation of the minor daughter of the informant. Let the notice be issued on respondent number two through the registry as part of prevailing notification issued by the Gauhati High Court. Notice to respondent number one is dispensed with as the learned APP enters appearance. A registry to call for the TCR in connection with sessions in bracket special case number 206-2025 from the court of the learned special judge POCSO, Kamrup Metro at Gauhati. Let the matter be fixed on
27th
27th.
February.
Made clear.
Yes.
It is facing trial in a POCSO case, Lordship. Facing trial in a POCSO case, Lordship.
Trial in POCSO, then we'll issue notice on
Notice
this.
and TC amala.
Notice will go, Lordship.
Okay, we had Mr. S.K. Poddar. And only we can keep in application, then the allegation relates to sexual exploitation of the minor daughter of the informant. Notice to respondent number two through the registry. Then notice to one dispensed with TCR. Registry to call for the TCR in connection with POCSO case number 162/2025.
Special Judge Morigan, Lordship.
From the court of the special judge POCSO Morigaon. Let the matter be fixed on
23-4 if possible. He is 18-year-old, Lordship.
okay 23
or 4, Lordship, as per your convenience, Lordship.
Okay, mala
24th.
24th.
Right, Lordship.
Notice has to be served.
I am on notice under section 47, Lordship. It is page 67, the NDPS case is not complied with, Lordship. Page 67 is a typed copy, Lordship.
So we'll call for the CD, we'll see.
So, Lordship, I have been arrested on Lordship 3/8/2024. It is, I have been languishing behind the bar for 1 year, 6 months, 9 days. But
1 year,
1 year, 6 months, 9 days.
Huh.
But charges, yet not framed charges, Lordship.
charge not framed.
Not framed, Lordship, trial is not initiated because final complaint has been submitted showing one accused person as absconder. For that reason, is it repeatedly fixed on for appearance, Lordship? Though final complaint has been.
So we'll
submitted-
call for the TCR, we'll see what is there.
Okay,
I mean, how it is producing,
Yeah.
I mean, process progressing,
Yes,
then
sir.
we'll see that.
It is on the appearances since 29/1.
Correct, if some inordinate delay is happening, then we'll have to find out why it is happening. And if, and the court has to see, I mean, if it can be expedited by
Yes, sir.
something.
It's not complied with.
And that we'll see, I mean, when the TCR comes. Heard Mr.
PK
PK Soria, the learned counsel appearing for the accused applicant. Also heard Mr. R.K. Dev Chaudhary. You are appearing as Mr. Chaudhary?
Deputy SGI,
Huh?
Lordship. Deputy SGI, Lordship.
The
Yes.
Deputy Solicitor
Yes,
General
learned
of
counsel.
India. India, this in application under so and so. Then you can write. The case relates to how much quantity were recovered?
934 cases of ganja.
934 kgs of ganja from the possession, from your possession,
Yes, Lordship.
from the possession of the accused
From the
applicant.
truck which was, I have read,
Correct, from the possession of accused applicant, full stop.
as per allegation.
For like the registry to call for the TCR in connection with.
That
mm,
would be NDPS case 1 pending before the additional district and session judge, Rongya.
correct. NDPS customer, so and so. Let the matter be fixed on when
Let it be after, in the first week of
March,
March, let it be on 6th, Lordship. if it is-
6th of March, 6th of March.
Takes. Made please your lordship. Lordship, item number 7 may as well be taken together. It's arising out of the same FIR, my lord.
6 and 7.
6 and 7, my lord.
Okay.
My lord, allegations are under the UAPA Act as well. Though,
Hmm?
my lord, there's
Allegation
absolutely no
other?
UAPA Act is also there, my lord,
Okay.
along with the PNS. So,
Hmm.
my lord, possibly case diary would be required, my lord, both the matters.
Okay.
But, my
heard.
lord, absolutely no material to the best of my instructions. So, I just pray for a short date. It's from Gauhati itself.
Okay. Heard Mr. D. Bodde, the learned counsel appearing for the accused applicant. Also heard Mr. K.K. Parasar, learned counsel, learned APP for the state. This is an application under so and so.
No.
The case relates to
Page- page-
what is the allegation exactly?
Lordship would find the FIR as page number 19, my lord. There's a typed copy with the copy is not yet clear. The allegations in crux is that, my lord, the accused petitioner
Hmm.
in the item number 6,
Hmm.
as well as the accused petitioners is item number 7, my lord, they were
Mhm.
traveling by a car.
Hmm.
And the interception happened under the Jorabat PS in the, my lord, Jorabat area.
Correct.
And the vehicle on being searched, my lord,
Hmm.
they had recovered about rupees 70 lakh in cash
Hmm.
and about 43 lakhs in checks, my lord.
Hmm.
What had happened is that, my lord, the petitioner number 1 in item number 7,
Hmm.
he had just on that day itself, my lord, sold a plot of land.
Okay.
So those were, my lord, proceeds.
So only this cash money and like
Cash
checks
money
were
and
recovered.
cash and checks were
Uh, uh,
recovered,
uh.
my lord. Absolutely. Otherwise, no tangible material, my lord.
Okay. Okay, the case relates to recovery of about 70 lakhs of cash rupees and checks amounting to rupees 40 lakhs from the possession of the accused as well as another co-accused. Let the case that be called for. Fix the matter on
My lord, they are saying 19. Okay, my lord, 19 I will try.
Bokisto, my lord.
19.
Thank
19.
you, oblige, my lord.
And the same order in the next the other case.
Item 7.
6 and 7 also same. Same.
Please, your lordship.
Yes.
Case report will be called for lordship, custom case. Lordship.
Okay, heard Mr. D made here. Learned counsel appearing for the accused applicant. Also heard
M.
N-
Deca.
M. Deca, the learned counsel appearing for the standing counsel customs. Recent application under so and so. The case relates to what was recovered?
Nothing has been recovered from the possession of the petitioner, lordship.
Probably
On the basis
he was
of-
implicated.
on the basis of a statement.
Okay, who was, I mean,
Page number 11, Lordship.
Anna Sali, one driver, lordship. From his possession, the
okay,
LSF
the
is-
accused, the case relates to, what was the recovery otherwise?
Fake currency, Lordship.
Case relates to recovery of fake currency from one person named what is his-
Annas Ali.
Annas Ali, who implicated the present accused applicant. Call for the case diary.
Lordship.
Let the matter be fixed on.
Next week, any date, Lordship.
19, lordship.
Put it on 18th. 18th? Okay.
And what was- NDPS commercial quantity, Lordship, still at investigation stage. NDPS commercial quantity, Lordship.
Okay. Hard MS so and so, learned counsel appearing for the hearing. Then also hard so and so is an application. Then the case relates to recovery of commercial quantity of narcotic contraband from the possession of, from your position? From whom, who's?
Vehicle was intercepted, Lordship.
So you are traveling in one vehicle?
Lordship. Two vehicle was, the registration, the vehicle
Mm.
registration, car 01E,
No, that is fine. How you are you got implicated?
statement for the co-accused.
Okay. Case relates to recovery of what otherwise? 52 packets of suspected heroin from one vehicle. And the traveler vehicle, and the accused applicant was implicated by the co-accused. Call for the case diary, let the matter be fixed on
Twen-
Today is
27,
177 days. It's a commercial quantity. One seven, hmm?
177 days. I'll take instruction, my lord,
You
otherwise.
take it, sir, we'll dispose it of otherwise.
My lord?
We'll dispose it of.
No, no, my lord, 177 days.
Only how many days are there?
3 days, maybe succeeded, my lord.
No, you take instruction, that's what I'm saying. You take instruction, when can you take this? I mean, when today?
Monday, my lord.
Monday it will be what? It will be more than 180 days.
181 days. Saturday, Sunday are holidays, my lord. Second Saturday. and-
Okay, list it on Monday.
Monday?
Let the matter be fixed on Monday.
Then
Pertaining to the instant case, item number 23 and this case is arising out of the same FIR. And
23.
CB has been received in relation to that case.
So we'll take it up with along with 23.
Item 10.
Item 10 and 23 together.
Okay.
11.
Application of Vista as high as it is number 20.
What are the allegations?
Otherwise, Your Lordship, the victim, that is the informant itself, Your Lordship, and the petitioner, number 2, Your Lordship. Here, as per the police, Your Lordship, he is happy Singh, Your Lordship, but he is not happy Singh, Your Lordship. One, namely, happy Singh got introduced in a matrimonial app, Your Lordship, in a dating app, Your Lordship. And after that, they developed their relation over phone, Your Lordship. The petition, the happy Singh claimed to himself as from Italy, Your Lordship. And that informant, Your Lordship. And
Is it some cyber fraud?
yes, yes.
My
yes,
lord.
Cyber fraud.
Something is there, Your Lordship, but this petitioner is not involved in this case at any cost, Your Lordship. So,
Okay, we'll see for, we'll call for the CD. Heard
permits-
Mr. MSG Boda, the learned counsel, appearing for the accused applicant. Also heard Mr. KK Parasu, learned APP for the state. This is an application, you write. The case relates to a cyber fraud. Alleged to have been involving the accused applicants. Call for the case diary. Let the matter be fixed on. When?
Not take me with fixed view because of caution.
Oh, die. 25th.
For them.
25th.
Your Lordship, Tuesday or Monday, because
No,
Your
no,
Lordship,
Monday.
what is my instruction, Your Lordship?
No, I mean, cyber fraud, we'll see. There are a lot of cyber frauds are happening.
This is Your Lordship, I can convince Your Lordship, this one.
No, you can convince on the schedule date on 25th. 25th.
Respect Your Lordship.
25th, madam. We have given a date. Cyber frauds, I mean, we'll see. I mean, if these are complicated issues.
Okay.
Can you do 20th, Your Lordship? My humble request, Your Lordship, because.
When? 28? No.
0, Your Lordship.
No, 20 not possible. 23rd. 23rd.
Your Lordship.
POCSO. What? Kidnapping.
Section 9.
What is the allegation exactly?
Section of YPC and section 9 of the Prohibition of Child in Marriage.
When arrested? Arrested.
22/7/2023.
Page 10 is the FIR.
Yes. The accused was arrested on 22/7/2025. And actually on page 10.
Evidence. Page 15 shows that next that is next that already gone 22-1, but evidence stays, Malad. Let the TCR be called for, Malad. Last page, Malad.
Mr. Parasar, I mean, I mean, allegation against him is only that the girl was in his place. Somebody else has taken it.
Yes, but
See,
what is the statement, how, matlab, why, matlab, since 7, huh? Almost 7 months he in jail, matlab, why?
he's already,
But-
he's
but-
in jail for last
That's almost 7 months.
7 months.
Yes, matlab, but what is the, matlab,
Man,
actual fact?
see the FIR, Mr. Parasar.
Hey, FIR, matlab, 10, matlab.
Already 7 months.
Subhakolta ghot. Yes, matlab, but what is the statement of the girl, matlab, Subhakolta, how he is entangled, matlab, maybe in his house, another thing, matlab, maybe his role, matlab.
The allegation is only that he was, it was
Yes,
kept,
yes, yes.
she was kept. Only we'll give you a short date to short date.
Yes, yes, yes.
Heard MS so and so, the council appearing for, your name? So and so, the council appearing for the accused applicant. Also heard Mr. KK Parasar, learned APP for the state. Is an application under so and so. The allegation relates to hiding the informant's daughter by one person in accused applicant's place for some time. Let the matter be fixed. A call for the CD, no, call for the TCR, registry to call for the TCR,
19, matlab.
TCR as per so and so. Let the matter be fixed on
19.
19th, yes, 19th only. 19th.
May I please, Your Lordship? FIR is on page 13, Lordship. This is an NDPS case, Lordship, intermediate quantity.
Mr. Poddar is having so many NDPS cases these days.
Lordship, may I draw just attention of 2 lines, Lordship, in the FIR?
And NDPS case, we usually
No,
this,
just one line attention. Lordship.
usually disco code by default gives notice.
No, definitely I am not. I am pressing on other ground, Lordship. Here in this FIR, Lordship, the 4th line at page 13. One drug detection, district drug detection unit apprehended one person while he was buying suspected NDPS item from Haibur Ali. The arrested person was Saiful. I am here for Haibur Ali, Lordship,
So, I mean, yeah, Saiful is the arrested person.
from my residence. I was not present in my residence.
So we'll call for the CD. we'll call
Matlab,
for
Lordship, I am pressing for an interim on medical ground, Lordship, page 15, Lordship.
Page 15, what is
Lordship.
there? How old are you? How old are you?
I am 35.
What
Lordship,
is?
here, the fracture noted at Miss Shaft, Lordship. Fracture on 6th
Fracture noted at
6th of February, Lordship, I have sustained fracture
mid,
injuries,
mid
Lordship.
what?
Mid shaft, ulna, this hand,
Okay.
Lordship. Doctor has referred me to for higher center for further management of orthopedic surgeon, Lordship. I have enclosed the X-ray report also, Lordship. I could not take treatment due to, as I have to remain avoiding arrest, Lordship. And nothing was recovered from me. One person, he came to my house. The drug showcase, 10 grams heroin was recovered from my residence, allegedly so, but contradictory statement have been made in the FIR that while Saiful was buying the land, buying the drug, he was arrested.
Matlab, Lana Senior has not shown the 3rd line, matlab.
I am showing everything. is showing.
Matlab, page 13, 3rd line, that a person, namely Haibur Ali and his wife, dealing with suspected NDPS item,
That's
they
why
are
I'm saying
dealing, they are.
No FIR, no single case is pending against me, Lordship. Not a single NDPS case is.
This is
against
the
me,
first
Lordship.
case.
Page 13, what my learned edition people is referring, Lordship. I am not a drug dealer. One person came to my house, I admit that, but Saiful was arrested from my residence. And I was not present at that time.
But from your residence, huh?
Yes, that is there, Lordship.
Your wife was there.
That was there, Lordship.
We'll give a short date, we'll
I
give a
put
short date.
interim protection, Lordship, only on the medical ground, Lordship.
No, medical is nothing. Medical is nothing. It's a small injury in this.
Fracture injury,
Well,
Lordship, I
fracture,
agree, some better treatment, Lordship.
fracture, but I mean, fracture injury, I mean, it's so common. I mean, you can get it anywhere. I heard Mr. My escape order done it, counsel appearing for the accused applicant also heard Mr. Parasa. Is an application under so and so. The case relates to, selling of,
Lahorigat case could be-
selling of suspected heroin from the house of the accused applicant. Full stop. Case diary, full stop. Did the case diary be called for? Call for the case diary. Fix the matter on
23
25th.
possible, or
25th.
24 on the earlier matter, maybe tagged, the same day it will be convenient for me, Lordship. if
24,
possible.
24.
24, Lordship.
Mm.
Okay.
14.
Made Rizal Lordship. Lord, the petitioner before your Lordship, he is a government servant working in the capacity as an administrative officer and office of district commissioner.
Hmm?
Election, my lord, he is working in the capacity as a district administrative officer in the office of district commissioner, election branch, my lord, Kamrup Metro, my lord.
Okay.
My lord, 11 years back, an inquiry was launched against him, my lord,
Mm.
alleging disproportionate assets, my lord.
Mm.
And the check period was taken, my lord, 20 years, my lord, 2006 to 2011, my lord.
Mm.
It was 20 years back, it was the check period.
Mm.
2015 inquiry lost, my lord. Nothing happened, my lord. Now this FIR file, FIR, my lordship, may kindly come to page 14, my lord.
So he continued doing that.
My lordship.
He continued doing that or what?
No, my lord.
He
That is not the
continued
allegation.
amassing wealth.
No, that is not the allegation, my lord.
Then,
May I read, my lord? Page
Yes.
14 FIR.
Mm.
With reference to the subject cited above, I have the honor to inform you that on one preliminary inquiry was conducted by this directorate by PE number so-and-so dated 28/1/2015. And the preliminary inquiry report was submitted by Sri so-and-so, Inspector of Police, Director of Vigilance and Anti-Corruption, Assam, on completion of the PE preliminary examination. The preliminary inquiry report was sent to the government of Assam seeking approval for initiating a regular inquiry. The government of Assam, by letter dated so-and-so Dispur, the 13th October 2015, accorded approval for initiating a regular inquiry against the Vikas Kakoti. 2015, my lord, approval was granted. Then subsequent para is with regard to my posting and all, my lord. Then third para, my lord, during the inquiry, the relevant materials documents were collected in respect of suspect officer. Analysis of bank account statement of SBI account number so-and-so belonging to suspect public servant. Sri Vikas Kakoti reveals that several amounts were credited during the check period, that is from 11/9/2006 to 31/12/2011. It is suspected that the suspect officer has credited disproportionate assets by means of such unaccounted money, as such money are mostly used in creation of assets. In this regard, an investigation through a regular case is required to find out the assets and liabilities of the suspect public servant. In course of inquiry, it is found that the suspect public servant Sri so-and-so accumulated most of his property between 2006 to 2011. Therefore, the check period for this inquiry was taken from 11/9/2006 to 31/12/2011. During inquiry, suspect public servant so-and-so could not explain about the cash amount of 5,40,000 and check amount of rupees 3 lakh deposited in his SBI bank account number so-and-so during check period, which are suspected to have been acquired through illegal means. The residential building owned by the suspect public servant so-and-so, covered by DAG number so-and-so, Pata number so-and-so, under Sila so-and-so, North Gauhati, District Kamrup, was evaluated and a report was received from the Executive Engineer, PWD Gauhati, Building Division. Number 2, Dispur, Gauhati, letter number so-and-so, dated 7/1/2017. In the report, it is mentioned that the ground floor of the house building was constructed in the year 2001 to 2002. First floor was constructed in 2008 to 2009 at the cost of rupees 16,79,980. And second floor was constructed in the year of 2013 to 14. This is important, my lord, this para. During inquiry, it is revealed that the suspect public servant Vikas Kakoti invested rupees 10,000 in Kisan Vikas Patro on 5/2/2017 in his name. During inquiry, it is revealed that the suspect public servant Vikas Kakoti paid rupees 18,228 as premium per year at Postal Life Insurance by policy number so-and-so, dated so-and-so, Total amount in 5 years was rupees 91,000. In his name during the check period. During inquiry, it was also revealed that suspect public servant Vikas Kakoti paid rupees 9,951 as premium per year at Bharati AXA Life Insurance by policy number so and so dated 28/12/10, and total amount paid in 2 years was 19,800. From the above analysis, it is found that total investment is much higher than the total income of the suspect public servant Vikas Kakoti from the given check period. So these are, my lord, my investment, my lord. My lord, check may kindly see 10,000 in Kisan Vikas Patro, my lord, 18,000 premium postal life insurance, 9,000, my lord, Bharati AXA life insurance, in a whole year, my lord. And now, my lord, since 2015, they have kept this case pending investigation, and now they have launched the prosecution without any explanation whatsoever as with regard to the delay. Why they have not caused any investigation, my lord, in that period of time, 11 years, my lord. And
Lordship,
the documents, this is a case of, my lord, documentary evidence. My lord, the allegation against me is disproportionate assets, my lord. The check period has been put, my lord, 2006 to 11, my lord. 20 years back. And all the documents pertaining to the present case have been seized now, my lord. At
Lordship,
this particular point of time, my only prayer is, my lord, that he is a government servant working in election commission branch, my lord. And there is no chance of abscondence. Documentary evidence, my lord, all the documents have already seized. Only allegation is, my lord, I have invested so and so much amount in my life insurance in a whole year.
Lordship, in this matter, Mr. P.P. Dutta is appearing, Lordship. He, counsel for CM Vigilance, Lordship. He is on Lake Scene, court number 9, Lordship. Can it be taken after some time, Lordship?
Okay, we have heard you, like, let him come, then we'll pass an order.
Obliged.
Procedural for 10 days. Withdraw.
Yes,
Heard Mr.
Islam.
A. Islam, learned counsel appearing for the accused applicant. Also heard Mr. K.K. Parasar, learned APP. Mr. Islam submits that he has instructions to withdraw this matter, withdraw the instant matter. Prayer is allowed. Matter is dismissed as withdrawn.
47, motion. For the timing, for the time. For the timing.
And we-
Then 19, then here.
Certificate case, my lord, scan copy was called for, my lord, that is received, my lord.
But respondent number 2
Yes, my lord. The service report is, my lord,
not received. As per office note dated. As per
Yes, sir.
office note dated 10/2/2026.
2026.
My lord, 19. I'm
Yes.
appearing for item number 19.
Huh?
I'm appearing for item number
Which item
19.
is
19.
19?
199.
The service is not
Not
completed
completed.
as yet.
But see, my appoint Amicus Curiae, my lord, this is second, third time, my lord. If lordship pleases, my lord.
It is seen from the office note that office note dated 10/2/2026 that service upon respondent number 2 is yet to be completed. Full stop. It is also the seen that the steps for service was taken on 29/11/2025. Since sufficient time has elapsed in the matter, the court is of the opinion that an amicus curiae should be appointed to assist this court on behalf of respondent number 2. Accordingly, Accordingly, Srimati Sanjana Newar is appointed as Amicus curiae to appear for respondent number 2. The learned counsel appearing for the accused applicant shall serve a copy of the application to the Amicus curiae within 2 days.
Minor.
Let the matter be listed. On 25th?
Minor.
25th.
20, can it be after sometimes, my lord? 20.
Okay, after some time. Twenty-two or 10 to लिखा सुनिए 22 पहले नहीं अच्छा
May I please, Your Lordship? Lordship, this is charge sheeted matter under section 21C of the NDPS Act, along with Red with 29. There were three accused person, and I am one of them. And Lordship, my grounds for filing this bail application is that there is non-compliance of section 47 as well as section 48 along with the arrest memo, Lordship. I have not been served the section 48 notice. Nobody from my family member received the 48.
48 will not be served on you.
No, not from my family member. The 48 which is to be served to the nominated person or any of my friends.
Arrest memo was given to you?
Arrest memo, in arrest memo, there is no signature of my relative. Arrest memo is in page 60 of my application, Lordship. There is no signature of my relative, and 48 has not been served to us. Arrest memo, page number 60 of my bail application, as well as it is there in the scan copy, Lordship. Point number 3, wherein the signature of relative has been kept blank. I have not been, nobody from my family member has been informed about my arrest. And 48 is not there in the record itself.
48 is not there in the record. Have you checked?
There is no intimation as to receiving of any notice from my family members, from any of my family members.
Mr. Bodo, you checked?
My lord, I have also verified, my lord. Let the report may be called for the trial court, my lord.
Why?
Whether the 14 notices, my lord, it may be, my lord, it may not come along.
But
with
what
the
about
state
arrest
of the
memo? What about arrest memo?
Arrest memo also, my lord, I have seen, my lord. The only one witness is required, my lord. Only one witness, my lord.
That is a statutory requirement,
Yes,
Mr.
sir.
Borua.
For that purpose, my lord, let the report may be called for, my lord.
No, why report? I mean, if it is not there, then it vitiates the whole arrest process. That this court has already held it.
The question is that, my lord, whether it is available in original or not, my lord. I am only.
You have been given this, so you verify from this. I mean, why? I mean, again, the report is required for this.
48, my lord, 48 notice maybe, my lord, it may be available in the.
No, it's not there already.
It is, my lord, sometime
It is not there, but and otherwise also this section 35 is violated.
Then let me, my lord, verify again, my lord.
Again.
Let it come,
Mr. Borua,
So many scan copy of the record, my lord. We are just going through one by one.
It is the necessary of verifying it at this moment, Lordship. The scan copies are already there.
No, if it is not, my lord, in the scan copy of the record, my lord, definitely, my lord, she has a case, my lord. Let me verify, my lord, once again.
No, this copy has been already given on affidavit, Mr. Bogo. Arrest memo has been given on affidavit. For arrest memo, I mean, violation of arrest memo itself he gets a right. You'll have to train your officers. And because of your officers only, I mean, they are getting,
I'm only paying for a salt that, my lord, just to go through again.
yeah, we can take it up in this afternoon. You go through it. We'll take it up in the afternoon. You go through, you check, you can call up and find out if 48 is
My
there.
lord.
And if there is, I mean, if the arrest memo, it looks like there is no signature.
My lord, go through again.
And if there is no signature, I mean, Supreme Court as well as this court has already held that is a statutory, I mean, mandate. I mean, that cannot be violated. So we'll take it up in the afternoon, Mr. Budua. You just find out.
23.
Yeah, it will do. Lordship, kindly pass over for time.
No, why all the time pass over? From, especially from your side, I mean, I always have seen the matter is taken up and pass over. I mean, we cannot go on only with the convenience of the lawyer, but I mean, we always accommodate, but I mean, court also has a lot of other things to do. Pass over for time being. I mean, once, twice, it's fine, but I can see always you take, I mean, from your side, always you take time. I mean, if, I don't know whether your lawyer reaches on time to the time in the court or comes lately. I don't know. If the lawyer comes lately, then this court cannot wait.
24.
None appeared when for the petition, none appeared for the accused applicant when the matter was called for. Let the matter be fixed in the next week.
25.
Here the petitioners are in custody since 18/8/2025.
My lordship, the informant seeks short accommodation to file affidavit in opposition.
All records are before your lordship, they can submit orally also.
The offense is heinous crime. And
That is the allegation, and if your
Victim is
lordship
also
sees the
defendant.
medical report, that completely negates their allegation. It is allegation that 4 persons kept the girl for 4 days and committed gang rape. And medical report says no, nothing is
The
there.
victim is deaf and dumb.
That is there.
So some sympathy should go to her. So like, I mean, let them file an affidavit, objection. When can you file it? Must be, I mean, I will not accommodate much time because last time also you appeared, right?
Yes.
Last time you appeared on,
Yeah,
on 9/2. So you should have, you could have already prepared that.
next
Objection.
date,
Next date means when?
within this week.
On the next week. Okay, next week, sometime on the next week. On, maybe on. Okay, we'll fix it on 24th. By the time you fill it, 24th, we'll fix it. Heard Mr. A. Ahmed, learned counsel appearing for the accused applicants. Also. The last time Mr. Ahmed has taken time. You have taken time last time.
On last day, it was for service report. So I thought that they will appear, lordship. Accordingly, we take time.
Anyways, we'll fix it on Ahmed so and so. And also heard Mr. R.J. Borua, the learned APP for the state, as well as R.I. Gogoi, the learned counsel appearing for respondent number 2. Mr. R. Gogoi, the learned counsel appearing for respondent number 2, prays for some time to file an objection in the instant case. Prayer is allowed. Let the matter be fixed on 24th of
They
February.
will be directed to file their affidavit on or before 19th, Lordship. Otherwise it may not tag with the record.
Let the matter be fixed on 24th. It is directed that the respondent number 2 shall file their objection on or before 19th of February and serve a copy to the to the parties concerned.
Outline. 38.
No? 38. Public.
No, please, Lordship. In this case, Lordship, I am like this in behind our for more than Lordship, 3 years, 8 months, 10 days, Lordship.
3 years,
8 months, 10 days. Lordship, here also, Lordship, under Sector 47 notice is not complied with, Lordship. It is page 50, Lordship.
what are the other grounds? What is the allegations? What are the allegations?
Because allegation from a gypsy, Lordship, 16.77 kgs of heroin,
18?
16.77 kgs of heroin has been removed.
Lordship may come to page 34.
Yeah, I am also on the long incarceration, Lordship. There are some orders.
34 years?
So far as the petitioner is concerned, Lordship, these are the materials against him.
But what about his grounds of 47 and
Apparently, Lordship, what I find is, Lordship,
hmm?
that's not complied with. And
47 not complied with?
that would be now on the, this is on the CRPC, so 50. So, and there's a decision of my lord sitting in a division bench where I had appeared in a NIA matter also. And there's another decision taking cue from the decision rendered by your lordship, which my friend has annexed at page 53. Technically, lordship, that has not been complied with.
And his other ground also, like, 3 years, 8 months.
No, that cannot be invoked as a rule. That would have to be seen in the facts and
Yeah,
circumstances of the
absolutely.
case. Now, here is a case where 16.77, that's a huge quantity, lordship.
Was a long incarceration can be a ground, Lordship.
No,
After some orders of the.
long
tax court, Lordship.
incarceration, lordship.
Then what is the stage now?
Evidences, Lordship, out of 13, only 5 witnesses have been examined, still there.
Out of 13?
Yes, Lordship.
5.
1-3. Lordship, charges framed in the year 2023, Lordship. Charges has been framed in the year 2023. It is 26.
23 when?
23, Lordship, 23/5/2023.
23 5.
Yes, Lordship. I have annexed the order. It is page 48. And 49.
It's been 1.5 years, lordship. He came on the witnesses,
Yeah.
47 notice you have given here.
Yes.
Where?
It's on page 50.
Page 50, Lordship.
48 is also not complied with. Page 50, the photo certificate code. Two lines notice. এইকেইটা মাটিবিলাক ক'ব লাগিব, কি বিলেনৰ notice এখন দি দিছে।
Forty-eight is there.
No, Lordship, simply a notice has been served to one Ganita Devi, wife of the petitioner. Lordship. It is 51. No section has been mentioned and the contents are almost same, Lordship.
Arrest memo is there.
This memo, I have the certificate copy. Probably
Lordship,
not, probably not, Lordship.
Hmm?
The PCR may reveal, Lordship.
Hmm?
Trial court records may reveal. That would be at annexure 11 of the Lordship, dash sheet, Lordship. The memo of arrest.
Can't be helped.
Lordship, if it can. be-
Nothing is there. Arrest memo, no signature. I mean, 47, 48 not complied with. 50, 50 on.
Lordship will kindly consider
Hmm.
the volume of the Now,
No,
it
volume,
has been-
yeah,
it has-
we do agree with you. We do
Yeah.
agree with you with the huge volume. But the statutory mandates you don't comply with, then there is vitiates the whole arrest process, making the arrest illegal. And it goes to the very basic.
In view of lordship's own order, I cannot.
I mean, it will be difficult now. And already another ground is that
Here, lordship, the
It-
trial has already come as now. It's in the middle of the trial, lordship.
the
And
charges framed on this
This-
thing.
23.5.
This ground could have been
Twen-
very well
twen-
taken up
20
at the initial stages. Now the trial is in the mid.
But these are also grounds should have been taken in the, initial stages, but problem is the Supreme Court Apex Court has come, given, whatever the Supreme Court has held,
Yes,
it's a strict compliance.
lordship.
And it gives an unfettered right.
I do agree, lordship.
So.
This is
on-
one issue I have to take up with the department.
Correct. That has to, they have to be trained properly. Otherwise, as you were saying, it's such a huge quantity. And these are totally antisocial activities. But still, the personal liberty is the topmost priority.
That is. in
So
view of
that
the
has been,
Supreme Court's-
that has been held by
that
the
is in view of
court,
the Supreme
jurist and
Court's-
everyone.
Supreme Court's
So-
order, lordship. Yes, I cannot.
So difficult.
I leave it to your lordship, but this is one issue I would like to take up.
Yes, you please take it up. Please take it up. In other cases, a normal case, I have told Mr. Parasar also. Those are the kind of things the police officials do. This is very apparent in all these
Yes.
cases.
They are not trained properly, lordship.
It's a simple thing only, very simple. It's not very sophisticated kind of thing that only thing is there's a couple of signatures we are required to take it.
That is.
You don't take it. Yes.
I leave it
Anyways,
to your lordship.
I'll pass the order.
Lordship.
तो ऑर्डर पास करिए भी सर उनका नाम तो लिखे लोगे इनको या मिसेस होरिया राइट
PK so here, lordship.
आई विल पास द ऑर्डर
Lordship. Definitely.
ये तो फिर करो वैसे इन ऑक्टोबर ये लोग Yeah, Mr. Doctor,
Lordship,
see, the period was 2006 to 2011,
Lordship, that is a sec period, Lordship.
correct?
Yes,
Then, and there are some description of some investments.
Lordship.
Those investments, I don't know what is your comment on that,
Yes,
but some investment in insurance, some investment in this.
Lordship.
Only thing is there are two amounts,
My lord,
right? 5,40,500
Lordship,
and 3 lakhs.
Lordship.
And another thing is that like it was, it happened long time back.
20 years.
Hmm?
Take period is 20 years, my lord.
Tech period is 2006 to 11, right?
6 to 11. And
So already more than 15 years.
11 or 15, my lord, 11 years.
So now suddenly why?
Lordship, what happened, Lordship, in this case, as per my instruction,
Hmm.
that in regular inquiry was initiated long back in 2015, Lordship.
Hmm.
Taking the check period from 2006 to 2011, Lordship, 2015. But it was, I don't know, Lordship, for I have no instruction why it was so pending so long, Lordship. Thereafter, the matter was, when the permission for according the regular case was sought for, Lordship, that it was granted on 22/1/26, Lordship. There was a requirement for permission for approval for registering a regular case. So this matter was came to register in the 2016 only. However,
But
Lordship, this
why
case
you
was
so much of?
yes, it was kept in the regular inquiry stage, Lordship. While seeking permission for registering a regular case, that matter, this FIR came to now be filed, Lordship.
That also, my lord, in
2015
2015 itself, my lord.
26.
No, 2006, my lord, this
That
permission was
page
granted, but
16.
2000,
Page
15,
15, Lord, they have specified, in this regard, an investigation for a regular case is required to find out, my lord.
No, that page
2015.
16, Lordship.
Where
second
page,
paragraph.
page?
Page 15, my lord.
15.
Yes, my lord.
Page 15, I have seen that. Yes.
Suspect, my lord, it is suspect that a suspect has created disproportionate assets by means of such unaccounted money as such money, mostly in creation of assets. In this regard, an investigation for a regular case is required to find out the assets and liabilities of the suspect public servant, my lord.
Yes.
Take period 6 to 11, my lord. And no explanation in the FIR, my lord, why, my lord, such delay is caused. He is a 59-year-old, my lord, in the verge of attaining and within the next coming year, my lord. Entire, my lord, documents have been seized, my lord. So last 15 years, I have not absconded, my lord. Why will I now, my lord, abscond if liberty is granted, my lord?
The preliminary inquiry report is there.
That, my lord, I don't have, my
You don't have it.
FIR, my lord, it is specified, my lord.
Lordship,
All-
first paragraph, Lordship. would
No,
be-
that is
The
there.
preliminary inquiry was initiated in 2015 itself, Lordship, first paragraph. And the regular inquiry was also initiated in 2015 itself, Lordship. Taking the check period up to 2011, Lordship. Thereafter, Lordship, matter was under regular inquiry, Lordship. Now, Lordship, page,
No, but that,
page 16, Lordship.
and thereafter you kept silent.
In the
and
regular inquiry
Silent.
stage, Lordship.
You kept silent,
was
and
under
you never sought for, permission for regular inquiry.
No, regular
Or
inquiry permission was sought for, Lordship.
sought for when?
Lordship, kindly see the first paragraph, page 14.
Hmm.
Accordingly,
Oh,
regular inquiry.
2015,
That regular inquiry initiated.
2015.
From
2015, that,
From 10/12/15, the case was under regular inquiry.
now then what happened?
What happened, Lordship, now page 16.
Hmm.
For clarification, Lordship, only.
Hmm.
That on 22/1, Lordship got it, second paragraph.
Then the allegations come,
No, no.
correct?
That on 22/10/2016,
Hmm.
Government of Assam has accorded approval by letter so and so.
When, which,
Or-
where?
Page, Lordship, page, paragraph, second paragraph, Lordship, page 16, 16.
Where, which
On-
portion?
On 22, Lordship got it.
No, where?
Second parameter.
Second paragraph, Lordship.
Second para,
On page 16, 16.
16, okay. 22, 1 to
On
126.
22/1/16, Government of Assam Political Vigilance Cell accorded approval by
No,
letter.
page 16, para 2.
Two, Lordship.
Para 2 is 22-1.
Yes, I am reading, Lordship.
On 22-1-2026.
26.
You
the
are
government of-
reading to 15.
That the government, no, 15, Lordship, page 14, first paragraph, Lordship.
No, you're confused. See, regular inquiry was initiated in 2015.
15,
Correct.
10/12/2015.
2015, 10-12.
Therefore,
Then you during course of inquiry, what happened, you have explained.
Lordship.
Then-
Thereafter,
then-
after that,
Preliminary and
On
regular both in the 2015.
15.
15. Then
Yeah.
on 21-206,
16, Government of Assam accorded approval for regular case. It is not a regular case, Lordship, for a regular case, Lordship. At Vigilance Police Station, Chief Minister Special Vigilance against the petitioner. Accordingly, Lordship, this FIR has been lodged, Lordship. So for lodging FIR, there is no delay. The case was under.
why not delay?
Yes.
From 2015, you have been inquiring.
Yes, inquiring.
2015 to
Case was under inquiry.
2026, almost 10 years.
10 years
10
under
years you
inquiry.
have done the inquiry.
Under inquiry, Lordship.
Huh?
Yes, it was under inquiry. Anyway, Lordship, but so regular preliminary inquiry was done. So in regular inquiry was-
Preliminary inquiry, see, preliminary inquiry, I don't know what you have done,
Yes,
but something has been done.
something has been
And
done.
then the inquiry, regular inquiry you conducted from 10-12-2015
Lordship,
till 26, almost, maybe till 20,
10 years.
22nd 1/2026. Then, for 10 years. Now, after 10 years, you are filing this regular case
yes, regular case.
and he's on the verge of retirement. What will you do?
No,
He should have given him opportunity some more years so that he could have prevented his case.
Now he is seeking, Lordship, bail, Lordship. So we'll investigate and file a final form after the regular case, Lordship, investigation of the case, Lordship. It is a very nascent stage whether his custodial integration would be required or not required.
Documents
May
have
not be
been
required.
seized by you.
Yes, my lord.
So normally, Lordship.
Page number 17
No,
to 24.
Hmm?
Page number 17 to 24, this is the documents number.
17 to 24.
My lordship.
Lordship, those documents were in the search and seizures.
Custodial interrogation is necessary in
these
this
are
case.
important.
After, my lord, say 10 years, my lord.
Heard Mr.
M.K. Das, my lord.
M.K. Das, the learned counsel appearing for the accused applicant. Also heard Mr. P.K. Datta, the learned special counsel, no? Special PP,
Lordship, special counsel.
special PP for
Additional special PP, Lordship.
additional special PP for CM vigilance,
vigilance.
CM vigilance,
CM as special vigilance.
special vigilance, full stop. This is an application under section 483, 82 of BNSS 2023 for praying for pre-arrest bail to the accused applicant in connection with PS vigilance case number 404/2026 under section 13(1) small e stroke 13(2) bracket, all this bracket, 13(1) bracket e small e stroke, you can look it from here, of the Prevention of Corruption Act 1988. So now you are working as what?
I, my lord, administrative officer in the office of District Commissioner, Election Branch, Kamrup M, Assam. I have annexed, my lord, page
Okay.
11, 10, my lord.
A preliminary inquiry against the accused applicant was initiated by preliminary inquiry number Roman 5 and AC 02/2025 alleging disproportionate assets acquired by the accused applicant. Thereafter, the government of Assam, wide letter dated 13/10/2025, given consent for a regular inquiry. Full stop. The regular inquiry bearing number 50 in bracket 12 bracket complete stroke 2015 was initiated on 10/12/2015. Full stop. For the inquiry, the check period was taken as 11/9/2006 to 13/1/12/2011. During the inquiry, it was found that the accused applicant has constructed first and second floor at North Gauhati, and there were two deposits amounting to rupees 5,40,000, 5,40,500, and 3,500 in his account, which the accused applicant could not explain properly. Could not explain properly about the source. During the inquiry, it was also found that the accused applicant has invested in Kisan Vikas Patra amounting to rupees 10,000. And he paid premium for postal life insurance policy of rupees 18,228. Thereby, thereby, he paid an amount of rupees 91,228 for 5 years as premium. It was also found that the accused applicant has invested and paid rupees 9,951 as a premium per year for Bharati AXA life insurance policy. And the total amount paid in 2 years came to 19,800 rupees. Therefore, on inquiry, it was found that the accused applicant has amassed those properties beyond his known source of income, that is salary from that is by way of salary as a government servant. Is it correct?
My lordship.
Government servant. Full stop. On 22/1/2026, after the inquiry, after the aforesaid inquiry, the CM vigilance cell sought for permission, sought for consent.
Okay, one correction.
Uh,
Lordship, that permission was sought for by the vigilance and anti-corruption. This inquiry and preliminary inquiry and regular inquiry was done by vigilance and anti-corruption. They sought for registering a case. Thereafter, case was endorsed to CM vigilance. There are two defined entities, Lordship, vigilance
Okay.
and anti-corruption and CM vigilance.
So this inquiry was done by?
Done by the vigilance and anti-corruption Assam.
Just right, I'll take it. Huh? Inquiry was done by?
Vigilance and Director of Vigilance and Anti-Corruption Assam.
Director of Vigilance and Anti-Corruption Assam.
Page 16 last.
Then after the inquiry, this permission was sought for regular
case.
Permission was sought for after the inquiry. Permission for registering a regular case was sought for by whom?
By Vigilance and Anti-Corruption.
Vigilance and Anti-Corruption Department from
the Chief Minister's political vigilance cell.
Chief Minister's political vigilance cell.
Sorry, Lordship, political within bracket vigilance cell department. Page 16.
Page 16 where?
Page 16, second paragraph. Political within bracket vigilance cell department, Assam.
Okay. You can write from political in bracket vigilance cell.
Government of Assam.
Vigilance cells department, Government of Assam. For registering a regular case at Vigilance Police Station, Chief Minister Special Vigilance Cell, Assam, against the accused applicant. Full stop.
Then Vigilance Cell accorded approval for registering a case at CM Vigilance.
Thereafter, on 22/1/2026, the Government of Assam Vigilance Cells Department,
Political Vigilance.
Political Vigilance Cell Department, Dispur accorded approval wide letter number on a wide letter dated 22/1/2026 for registering a regular case at Vigilance Police Station, CM Special Vigilance Cell, Assam, against the accused applicant to investigate about the disproportionate source of income of the accused applicant. Being in an expert, the learned Mr. M. K. Das, the learned counsel appearing for the accused applicant, submits that the accused applicant is presently working as an administrative officer in the office of the deputy commissioner, no?
Administrative officer in the office of District Commissioner, Election Branch, Kamrup Metro. Assam.
Kamrup Metro. And during the check period, he was working as
He was,
LD.
my lordship.
He was working as a LD assistant and he was posted in North Gauhati. The learned counsel for the submits that from the inquiry, whatever has been seen or from the inquiry which has been narrated in the FIR dated 2/2026. Only two small amounts, that is rupees 5,40,500 and 3,05,500 were there in his account, and all other allegations are regarding certain personal investments made by the accused applicant amounting to small amounts during the period of 2006 to 2011. Full stop. He further submits that the accused applicant further submits that the investigating authority took about 10 years to complete the inquiry, which has itself caused immense hardship to the accused applicant. He further submits that the accused applicant is in service and he is going to be superannuated in the next year. He submits that taking into account the aforesaid facts, the accused applicant should be allowed to go on an anticipatory bail at this stage. Full stop. On the other hand, Mr. P.K. Dutta, the learned counsel, appearing for the CM Vigilance Cell, opposes the bail at this stage. What will be your more submission? Opposing the bail application at this stage without perusal of the case diary in the instant case. Full stop. This court has given careful consideration to the submissions made by the counsel appearing for the respective parties. Having after taking the whole facts in its entirety, and also taking into account the delay that has been caused in seeking approval for registering a regular case, which is about 10 years of time. This court is of the considered opinion that at this stage the custodial one more thing, also taking into account of the fact that all necessary documents and papers have already been seized from the accused applicant, is of the considered opinion that at this stage custodial detention of the accused applicant may not be required. Full stop. In view of the aforesaid, in view of the aforesaid, it is directed that in the event of arrest of the accused applicant by the investigating authority, the accused applicant shall be released on bail on furnishing of bail bond of rupees 1 lakh with two local sureties of like nature to the satisfaction of the arresting authority, subject to the following conditions. Three conditions that we usually put, you give it, three conditions you put it. Where I'm disposing it. In view of the aforesaid direction, the instant bail AB application is disposed of. Let him be outside. You have already seized all those materials. You do he'll cooperate.
My lord.
I'll give strict instructions to
My lord.
cooperate. He will appear within 7 days. Then some other conditions will be put in.
Governments are
Not required.
deeply obliged.
I'll just come back in 5 minutes.
With all respect. Here, my lord, NDPS, my lord. My lord, on the spot, my lord, 2 persons were arrested, my lord, from 2 different vehicles, my lord. Seizure is on the spot, my lord. Commercial quantity, my lord. Same forwarding report they were forwarded, my lord. And thereafter, my lord, with all respect, my lord, because of violation of, my lord, with all respect, my lord, constitutional as well as, my lord, statutory rights, the other has been granted the privilege of bail. Exactly the same status, my lord. May I just place it, my lord? My lord, we have filed, let me come to the FIR, my lord, that occurs here in the main application, page 18, my lord.
Page 18.
Page 18, my lord. 18, 19, and 21. Those are, that may not be of much material, my lord, because, my lord, the bail has been granted not on merit, my lord, because of the violations, my lord. And
Yes.
Violations, my lord. May I read the order of the court, my lord, by which bail has been granted, my lord? That would be
Where is that?
127 of the additional affidavit, my lord. Yellow flag, my lord. Sir. This. And there, my lord, with all respect, my lord, page 127, para 7 is very important, my lord. Same forwarding report, exactly the same contents, my lord. 127, para 7, my lord. Because production was carried out, that statutory period of 24 hours, my lord, it was much subsequent to that. 5 was subsequent to that.
Yes, page 127, para 7.
Para 7, my lord.
Yes.
May I read?
Yes.
As already discussed herein above, from the contents of the CD, it is evident that the petitioner was in the effective custody of the police from 7:20 p.m. on 17/4/25, and the period of 24 hours should expire on 7:20 a.m. on 18/4/25. And even allowing a period of 2 hours for transportation, which is on the higher side from, my lord, this is a place, my lord, of National Highway 37 to the court of CGM Sri Bhumi. The permissible period for production before the nearest magistrate would expire at 9:20 p.m. on 18/4/25. However, admittedly, the petitioner was produced before the learned additional CGM at Sri Bhumi at 3:40 p.m. on 18/4/25. As held by the apex court in so-and-so, 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 the arrest stood vitiated on completion of 24 hours in custody without being produced before the nearest magistrate, and that once a court dealing with a bail application finds that the fundamental rights of the accused under Article 21 and 22 of the Constitution of India have been violated, it is the duty of the court dealing with the bail application to release the accused on bail, my lord. On these grounds, my lord. That apex court, my lord, it was a PMLA case, my lord. PMLA, my lord, that occurs for, my lord, primarily, my lord.
Which paragraph of this?
My lord, with para 4 first, my lord. May I read?
So here also the time period is discussed.
Exactly same.
And then?
Them. Only that, my lord, thereafter, my lord, para 8, my lord. May I just read it, my lord?
Yes.
With all respect, my lord. Once a court, while dealing with a bail application, finds that the fundamental rights of the accused under Article 21 and 22 of the Constitution of India have been violated while arresting the accused or after arresting him, it is the duty of the court dealing with the bail application to release the accused on bail. The reason is that the arrest in such cases stands vitiated. It is the duty of every court to uphold the fundamental rights guaranteed under Article 21 and 22 of the Constitution of India. Because first of all, my lord, 24 hours is a constitutional mandate under the Article 22(2), and thereafter the statutory mandate under under section, my lord, concerned section of the BNSS, my lord. I get, my lord, a further leeway benefit of 5 more minutes, my lord. That occurs at page 108, my lord. So far as I am concerned, my lord.
8 minutes for what?
My lord.
8 minutes for what?
My lord, I was arrested 5 minutes prior hand, my lord. The person who has been accused, who has been granted the privilege of bail, my lord. Of course, my lord, doesn't make any difference, my lord. Anyway, my lord, there is a further benefit of 5 more minutes, my lord. Page 108, my lord. In custody, my lord, date and time of seizure from 7:20 AM. And in Niranjan Singh, my lord,
Yes.
that, my lord, with all respect, my lord, has not been discussed, but my lord, their para 7 is of much importance, my lord. When a person is in custody has been defined in Niranjan Singh, my lord, para 7, my lord. Little bit elaborative, my lord.
Yes.
Like violations of 35(3), my lord, 47, 48. Here, my lord, the same mandate, my lord. 58 BNSS, my lord. And 62 BNSS, my lord.
Fifty 24 hours.
My lord, my lord, my lord.
And 62 strict compliance.
Exactly, my lord. Exactly, my lord. Flowing for Article 22(2), my lord, 24 hours stipulated, my lord. Produced together by the same forwarding report, my lord.
Okay, Mr. Borua.
The date of it is 18/4/2025, 8:30 PM. And the forwarding report, it is on the page number 53. The same day, he was forwarded.
After 24 hours. He was arrested on 18/4. What time? Lieutenant, produced before the, see, his contention is like not arrest, production before the magistrate. Same day, what time? Then have you gone through this, I mean, other order? Hmm. The same case? Same arrest, same forwarding report, same time period?
Same,
They have
time.
been taken together only?
Yes, yes.
That was made on the earlier day.
No, see, I mean, seizure was made, they were arrested, and they were supposed to be taken to the, I mean, nearest magistrate within a period of 24 hours. His contention is that the 24 hours, that mandatory period that has been prescribed under 58 of the NSS has not been complied with. There was violation of Article 22 and 21 and 22. No, Mr. Borua,
My
see, this order has already been passed by one coordinate bench, taking into account all these factors. I mean, do you have any problem with this?
Let him peruse, my lord, page 124, para 5. Some temerity has to be there, my lord. 124, para 5, my lord. CD side is a two CD sweater down, court CD sweater down.
So, I mean, he was arrested, Mr. Mahajan,
My
you
lord.
said arrested at what time?
On 17/4, my lord,
17/4,
25,
25 at
at 7:20 AM, my lord,
7:20 AM.
in police custody, my lord.
Yes, then he was taken out to magistrate at what time? 3:40.
My lord,
3:40 PM on
Yes.
18th.
taken at 3 PM and produced at 3:40 PM,
3:40 PM produced
my lord,
on 18/4.
my lord, my lord.
So by, 7:20 AM on 18th.
My lord.
So 24 hours is over.
Over.
And time taken for traveling has been also taken into account.
2 hours extra, my lord.
Probable time, possible time, taking it, 2 hours has been taken.
My lord.
If it is 5 hours also, then also it could have, it should have
Yes,
been
yes.
more than, before 3:40.
Before 3.
Mr. Borua, will have to allow him. Why?
My lord, then my lord, one line should be added, my lord, that further detention, if he is ultimately released on bail, whatever be it, my lord, that illegal detention, it would be borne by him, my lord. That line may be added and let it be sent there, my lord. There's some temerity has to be there, my lord, uniformity. Nowadays, state policy is to oppose even in a pen theft case, my lord. That is good. But when it is constitutional right, my lord, one should keep.
Is there any notification or rule from the Gauhati High Court? Is there a notification?
If the bench is taking up same matters, my lord, criminal matters. Otherwise, my lord,
No, if there is something you produce before the court, we will consider it, and the same matter has to be given. No, Mr. Borua, see, I mean, all the things are before you. CD is before you. His only argument is that he was, that accused applicant was produced beyond 24 hours. So you need to see whether it is there or not, or if there is some technical difficulties regarding, taking up this matter, then you can.
Yes. Caesar, this is annexed, my lord.
It's annexed there.
Clarified, my lord.
It has given
Caesar, this is
7:20 AM.
Let me place for my lord, with all respect, my lord. Caesar is page 113, my lord, and 7:20 AM. Caesar,
That has been shown by him already.
7:20 AM. 17/4/25, 7:20 AM. Crystal clear, my lord. ঠিক আছে। My lord, he has seen it, my lord, apparent, my lord.
Search and seizure at 7:20 AM.
Exactly.
Hmm?
17-4, my lord.
Correct, 17/4/2025, seizure was made at the same time he was taken into custody.
Custody, my lord.
Then he was mandatorily, he has to be taken to the nearest magistrate.
My lord.
Now nearest magistrate, while taking nearest magistrate, he was produced at 3:40 PM on
18, my lord.
on 18/4/2025. So his contention is that it's beyond 24 hours. And the coordinate bench has come to a conclusion that by traveling also, whatever mode, it will not take more than two
Exactly.
hours. So I mean, latest he should have been at least produced by 9:20 AM. So he was produced at 3:40 PM.
My lord, my lord.
So
Definitely, my lord.
this has gone beyond that, beyond 24 hours. So Supreme Court has, I mean, already held, and that's a statutory provision. That's a statutory provision.
My lord.
So violation of that, he gets a right.
Entails, my lord.
Heard Mr. B.K. Mahajan, the learned counsel appearing for the accused applicant. Also heard Mr. R.J. Burwa, the learned counsel appearing for the learned APP for the state. This is an application filed under section 483 of BNSS 2023, praying for bail in respect of the accused applicant, namely,
My lord.
Wahia Khan, YAHIYA, Wahia Khan, in connection with special NDPS case number 37/2025, 25, which is pending before the Court of Learned Special Judge Sri Bhumi, arising out of Badarpur PS case number 76/2025 under sections 22 in bracket small c stroke 25 stroke 29 of NDPS Act 1985. An FIR was lodged by one Dibakar Gogoi, SI, in charge Molua PICP, before the officer in charge of Badarpur Police Station, alleging inter alia, that credible that on receipt of credible information regarding movement of two suspected vehicles, the two vehicles suspected to be involved in transportation of narcotic contrabands,
Yaba tablets, my lord.
narcotic contraband in bracket you can read yaba tablets.
Page 21, my lord.
Yaba tablets. The police intercepted one Bolero pickup vehicle bearing registration number AS01 capital M capital C -2815, and another Bolero camper in bracket goods carrier without a number plate, and route from Silchar to Sribhumi via Badarpur. Full stop. The aforesaid two suspected vehicles were intercepted at Kandigram, Jabalpur. The driver of the vehicle, the driver of the vehicle, or the driver of one vehicle, that is AS, that is with registration number AS01MC dash 2815, identified himself as Wahaya Khan, the present accused applicant, and the other driver identified himself as Sumanuddin, who was driving the
Camper.
who was driving the Bolero camper. On interrogation, the driver of the vehicle, namely Wahia Khan, confessed that Yaba tablets were being transported from Manipur, which were concealed inside a secret chamber inside the vehicle. He also admitted that he intended to hand over the suspected Yaba tablets to the Bolero camper that was following him. Subsequently, in the presence of independent witnesses and the Superintendent of Police, Sri Bhumi, a search of the vehicle, that is AS01MC 2815, was conducted, and suspected Yaba tablets were recovered from a secret chamber located in front of the radiator. The total weight of the suspected Yaba tablet seized was found to be 16,673 grams, in bracket 16 kg, and 673 grams were seized by the police along with other articles. Full stop. Next paragraph. On receipt of the FIR, Badarpur PS case number 76/2025 under sections 22 in bracket C/25/29 of NDPS Act was registered, and the accused persons were arrested. (113), right?
My lord,
That's seizure and arrest.
type copy is 108, my lord.
108. But I mean, in the other order,
My lord,
it has been mentioned that 18/4/2025. Why is so? It's wrong or what?
my lord,
Arrested on, if you come to page 124,
my lord. In the arrest memo, it is shown as that, my lord, as he pointed out earlier, my lord. But they were in police custody for that seizure list I showed, my lord. That would be the time and the date of arrest, my lord. As per Niranjan Singh, my lord.
arrested on 18 and arrested on, ठीक है बने? And arrested the accused persons on 18/4/2025 and forwarded to the learned court of Chief Judicial Magistrate, Sri Bhumi. Full stop. Mr. B.K. Mohajan, learned counsel, appearing for the accused applicant, submits that though the arrest was shown at as shown as on 18/4/2025. In fact, the accused applicant was arrested on 17/4/2025 at 7:20 AM.
My lord.
In this connection, he has referred to the search and seizure list dated search and seizure list in connection to Badarpur PS GDE number 32 dated 17/4/2025, which has been annexed in the additional affidavit filed, which has been annexed as Annexer H in the additional affidavit filed by the accused, filed in the instant bail application. In view of the aforesaid, the learned counsel submits that the accused applicant was in fact taken into custody at 7:20 AM on 17/4/2025. Full stop. He further submits that the accused applicant was produced before the Chief Judicial Magistrate. Where do I get it?
My lord,
That forwarding report.
Yes, my lord, I'm guessing the page, my lord. It is in the order, my lord, page 127, my lord. Para 7 and forwarding report, my lord, page 23, my lord.
Page 23.
Page 23, my lord, date is towards the right, my lord, 18/4/25.
So where is the time?
Time only in a scan copy of the CD, my lord, as has been perused by the coordinate bench, my lord. That occurs at, my lord, page 20, order to page 127, my lord. Same forwarding report, my lord, same contents.
He was forwarded and no, the accused he submits that the क्या last line? Magistrate on 18/4/2025 at 3:40 PM, which is evident from.
My lord, evident from the order of the coordinate bench that occurred.
That is different, but like, I mean, 1 second.
Last bunch, my lord, pink flag. Third pink flag, my lord. (7:20 AM) could not be forwarded, my lord.
Okay, produced before the Chief Judicial Magistrate at 3:40 PM. Therefore, he submits that the accused applicant was in fact kept in police custody without producing him before the nearest judicial magistrate beyond 24 hours time. He submits that by producing the accused applicant beyond 24 hours, which is mandated under section 58 of BNSS, is violative of the statutory statutory provision which gives the accused applicant an unfettered right to get bail in the instant case. In this connection, the learned counsel has referred to the case of Niranjan Singh and another versus Prabhakar Rajaram Kharote and others, reported in 1982 SCC 559, Directorate of Enforcement versus Subhash Sharma, reported in 2025 SCC online SC 240, as well as the case of Suman Uddin versus the state of Assam, in bracket bail application number 4052 of 2025, bracket complete, decided by a coordinate bench of, decided by Gauhati High Court, decided by a single bench of Gauhati High Court on 29/1/2026, full stop. Referring to the aforesaid cases, the learned counsel submits that the Honorable Apex Court as well as this court has held in the aforesaid cases that in the event of the arrested person is not produced within a period of 24 hours to the nearest magistrate, the accused person is liable to be released on bail, being the arrest is in violation of the mandates of section 58 of BNSS, which in fact curtails the personal liberty that has been granted under the Article 21 and 22 of the Constitution of India. He further submits that the co-accused in the instant case has already been granted bail on the same ground by the coordinate bench in the aforesaid case of Sumanuddin Supra. In the instant case also, the accused applicant being similarly placed should be allowed to go on bail, go on bail due to the apparent violation of section 58 of BNSS. He further refers to section 62 of BNSS, which provides for strict compliance of the provisions of the BNSS while arresting an accused person under the BNSS. Full stop. Per contra, the learned APP submits that. What will be your submission? Submits.
838, and on the same day, my lord.
He was put. The learned APP submits that as per the materials available in the case diary, the accused applicant was in fact arrested at 8:30 AM on 18/4/2025, and therefore, and he was produced before the before the Chief Judicial Magistrate Sirbhumi at 3:40 PM on the same day. Therefore, there is no violation of section 58 of BNSS. Therefore, the accused applicant should not be granted bail at this stage. And what about this case? What will be your submission on the case, the coordinate bench's case? No, I mean, you'll have to make a submission on that also because he has referred to this case. No, whether that case can be distinguished on or something, then. Anyways, I'll leave it. I mean, you don't have any submission on that.
It has also gone down to the record matters after the material matters, they pass the order.
Anyways, in view of the aforesaid submission, he opposes the prayer of the accused applicant in the instant bail application. This court has gone through the case diary that has been as well case diary that has been produced before this court. It is seen from the seizure list. It is seen from the 103.
Page 108, madam.
It was seen from the search and seizure list dated 17/4/2025, wherein the date and time of seizure was clearly mentioned as 7:20 a.m. It also appeared from the CD that the accused applicant was apprehended at the same time and taken to Badrapur police station, and thereafter he was shown arrested on 18/4/2025 at 8:30 a.m. The aforesaid facts makes the aforesaid facts makes it clear that the accused applicant was in fact taken into custody by police at 7:20 a.m. only, when the accused applicant was apprehended along with the seized materials. Correct?
On 17/4, madam.
On 17/4/2025. The materials available in the case diary also reveals that the police proceeded from the police station from Bradalpur police station at 3 p.m. to the court of CJM at Sribhumi, wherein he was produced at 3:40 p.m.
On 18/4, madam.
on 18/4/2025. This is correct, no? This is correct. On a query to the learned APP, he confirmed that this fact is correct. Fact about, taking him from police station to this, only that fact. On the record only, confirmed that the fact of taking the confirmed the fact of taking the accused applicant from the police station to the CGM is not disputed by the prosecution. Next para, you read. The Honorable Apex Court in the case of Niranjan Singh Supra,
Para 7, madam.
At para 7 of the case has held as under. This para 7 you can quote, para 7 and 7 quote. Next para you read, in the case of Subhash Sharma Supra, the Honorable Apex Court at para 4 and 8
6 and 8. Four, 6 and 8, man.
Yes, 4, 6 and 8. 4, 6 and 8. 4, 6 and 8 is a quota. I'll just give it to you. The next para. Coming back to the facts of the case, as discussed above, it is evident that the accused applicant was in effective custody of the police since 7:20 a.m. on 17/4/2025, and the period of 24 hours would expire at 7:20 a.m. on 18/4/2025. Full stop. Even if a period of 2 hours is allowed for transportation, which is obviously on the higher side of time to travel from Jalapur Kandigram on on NH 37 to the court of CJMs at Sribhumi. The permissible period of production before the nearest magistrate would expire at 9:20 a.m. on 18/4/2025. Therefore, admittedly, the accused applicant was produced before the learned CJM at Sribhumi. No, they're not therefore. Sribhumi beyond 24 hours time, which has been mandated under section 56 of BNSS. In the instant case, admittedly, the accused applicant was produced before the learned CJM at Sribhumi at 3:40 p.m. on 18/4/2025. Full stop. In view of the judicial pronouncements of the Honorable Apex Court, as referred above, the arrest in the instant case stands vitiated due to non-production of the accused applicant within a period of 24 hours of his arrest before the nearest magistrate. Full stop. From the aforesaid facts, it is discernible that there is a violation of the mandates of section 58, read with section 62 of BNSS in the instant case, which goes to the root of the matter, making the whole arrest procedure vitiated, being violative of Articles 21 and 22 of the Constitution of India. Full stop. Before parting, this court would like to point out that though a huge quantity of narcotic contraband materials, that is Yaba tablets, were recovered in the instant case, the personal liberty of a person as provided under the Constitution of India gets priority, and any violation of his liberty which is not as per the procedure laid down by the prevailing laws cannot be brushed aside. Full stop. In view of the aforesaid discussions and taking into account the statutory provisions as well as mandates of the mandates of the judicial pronouncements by the apex court, this court is of the considered view that the accused applicant should be released on bail at this stage. Because of violation of statutory provisions while arresting the accused applicant. Full stop. Therefore, it is directed that the accused applicant shall be released forthwith from the judicial custody.
My lord, my lord.
Judicial custody on furnishing of a bail bond of rupees 2 lakhs,
My lord.
2 lakhs with 2 local sureties, at least one of whom should be a government servant to the satisfaction of the concerned court below in connection with the aforesaid case, subject to the following conditions. I'll put some conditions.
My lord.
In view of the aforesaid directions, the instant bail application is disposed of as allowed.
Highly obliged. Pleasure.
Right, your lordship, my lord.
Yes,
Can you see page 11, my lord, FIR? Here is a case model, just a background of the case, my lord. Your lordship will find page, first inform, page 9, my lord. Page 9.
page 9, yes.
Page 9 is over here. This, your lordship will find with due respect, I beg to state that my daughter and so student of class 9 on so at night, when my daughter went to toilet, the belongings of the accused who was waiting there caught my minor daughter and so. As my daughter started he and cry, he pressed her and threatened to kill her. On hearing, his sister-in-law, Baby Khatun, rushed to the place of occurrence, but the accused fled away. Though I tried to catch the accused, but he pushed me and fled away. In the morning, I went to the house of the accused to apprise the incident to his parents, but they abused and chased me. Earlier also, you will kindly note this is, earlier also on 26/8/25, the accused had committed bad things with my daughter, but considering her future, the matter was resolved. Now, kindly come to my lord, there is that agreement, my lord. That resolved, my lord. In fact, she herself is liable to be punished, my lord. It was section 21 of the act, my lord. Your lordship, kindly come to page 27. Page 28, my lord, and
This was done earlier.
earlier, that which she referred. What she is saying, madam, both the parties, and your lordship will find both the parties, she said, page 29. After lodging this case, your
But this is not type copy. There is no
type I will given my page 26.
page 26.
6, madam.
Yes.
So it is an agreement, madam,
Hmm.
that between both the parties. Regarding that earlier occasion, madam. I so and so Amjad, so
Then let's see what was the thing there earlier.
earlier, your lordship,
Who is this the accused is
Accused is
Rasul Haq.
His father is Amjad Ali.
Father is Amjad Ali.
Amjad Ali.
And Rafiqul Ali is the complainant,
Victim's my lord father.
victim's father.
His father.
First party, the father, Rasul Haq. Rasul Haq not attain majority as per also minor. Home was their marriage. Thereafter, due to misunderstanding, second, he lost the affair, so and so. After losing the case, both the parties ready to make a settlement. Parental decided to okay, so there was a agreement for marriage.
Marriage.
Then-
After attaining, both boy is married 19 years.
Correct, then?
He needs to 21 years, man.
Correct.
So that was going on. Subsequently, they got a better option, my lord.
Subsequently, the girl got a better option.
They got a better option, my lord.
Oh, the
Better-
girl.
Yes.
Yes.
my lord.
So marriage was broken.
Well, not working, they inform that you don't come to my house. Because of that agreement, they are coming with each other, my lord. So subsequently, they told they don't come to my house. He went there, my lord, saying that because we love each other, there is an agreement. We have made a statement on oath, my lord. So there are some
No,
alterations.
after the agreement, I mean, he still, wanted to marry the girl.
Yes, my lord, yes.
The boy wanted to marry the girl,
They wanted to marry her, they got a better
but the
option.
parents did not want a word.
Subsequently, after the agreement, my lord.
After the agreement, parents didn't want,
That my girl's parent, my lord,
girl's parent didn't want.
did not want.
Okay, girl's parent did not want.
Girl's parent did not want.
Okay.
And they
So,
wanted
so,
another person.
but the boy wanted it, so he went to the house.
Went to the, because there is an agreement already, my lord, that they will marry each other.
Correct.
The simple, they, in presence
So
of.
he went, then he was caught.
Altercation took place.
Hmm.
They don't come to our house. That he also said that why. That altercation was thereafter he was filed, man. This present FIR was filed. Page 31, your condition. Cardiac was withdrawn, my lord. Page. Your lordship, no, page 31.
So page 30, the withdrawal,
Yes,
the earlier case.
earlier case, withdrawn.
It was allowed, the
Yes,
withdrawal.
withdrawn is allowed, my lord.
Where is that?
That allowed, my lord. Because simply said, madam, prayer for withdrawal she has given to the IO, my lord, not to the court. It may be in the city, my lord. IO,
And what is this 17 to 12 order?
17.
12, page 32?
That is our present, and they have my lord the brief. It is also saying in this case, charge sheet is submitted, and one of the offense charge sheet is sections are there in view of the submission of charge sheet. Serious offenses will take into consideration of section.
Now, from where these
They rejected.
facts are coming?
They rejected. Law court below. Simply because charge sheet file.
No, this facts, this page 32,
Yes,
the middle paragraph, the brief fact of the case is that on 610,
right.
that these facts are different. From where these facts are coming?
The 610 is coming fact from the present FIR.
Hmm?
Present FIR.
But present affair is saying something else.
No,
Where is the present affair?
page 9.
Page 9.
6, 10, 25 is the, my lord, that date of occurrence.
The 710 it was filed, right?
Now you'll kindly see what they have.
No. See, what I'm saying is that the brief fact of the case is that 710 at one accused person Rasul Haq,
And
Azmat Ali,
father,
and some unknown persons.
no,
But this is not coming
this
from
is wrong.
this is not coming from this.
No, this is the wrong, my lord. But the father, son, and some other person, how it comes in the order, my lord. But FIR does not say, FIR say only about Rasul.
That's why I'm
That's
confused.
right. Your
Why
lordship,
this is
that's right,
happening?
my lord.
Hmm?
Now he is in custody matter for 70 days now.
Custody for
70 days.
17,
170.
70 days.
He arrested on 12/25. Charge, everything charge also frame, my lord, and so custodial interrogation at this stage, my merit alia also merit, my lord. They have withdrawn the case, they filed it. Thereafter, my lord, we have taken an oath. Only by the page 9 he says they abused, Though I tried to catch the accused, but pushed me. Thereafter, in the morning, I went to the house of the accused to apply. in
No,
the-
from where this
From-
rape has come, rape has come. In the order,
Yes.
that's a little bit puzzling. Mr. Borua, you see, rape, is there any rape committed? There is no allegation of rape.
Page number 16, my lord.
Page number? Page number? 16. 16 is what? 16 is?
Vernacular. The rape is.
No, page 9 is what then?
The 9 is same matter, translation.
Huh?
Translation, English translation. It is there what you stated. When my daughter went to the toilet, the accused who was waiting, minor daughter, and raped her against her.
Hmm?
With translation.
Mm,
Sulhok says, Amjad and others, nothing mentioned. about
that is not there.
Yes.
Mm. How old is this boy now?
19 years, madam.
19 years. Girl?
Girl is 15 years.
A charge is framed and nobody has.
May I please, your lordship? My lord, for Anajil mentioned, my lord, item number 18, my lord. In this case, Mr. RL, you will be appear. Well,
Which item?
item 18,
Theater possible.
admission matter, my lord.
Ah.
Admission matter in the criminal. In this case, RL have to appear, but he suddenly left the court due to some personal difficulties. So, for accommodation, my lord.
18, okay. Item number 18 on the prayer of Mr.
H.A. Ahmed.
H.A. Ahmed. Let the matter be fixed on when?
Any date, my lord.
Fixed on 25th,
Lordship.
25th. You record his, Mr. R.G. Bodo appears for, additional PP appears for the state. And Mr. So-and-so appears for respondent number 2. Hmm, hmm. 21/6 from here. Twenty-one six, okay. Hmm.
This is the order when they issue for the police for the production.
But your contention is that?
There is no signature of any witnesses in the arrest memo, as well as 48 notice has not been served to any of the friends, relative or nominated person of the petitioner. These are my two grounds which directly goes against the constitutional mandate of the petitioner. The arrest memo is in page 60 of my petition. As well as I have flag marked the same in the scan copy lecture.
Forty-seven is complied with.
47, to be precise, if I go for in the line of Mihi Rajesh Shah judgment of the Honorable Supreme Court with regard to the time of producing. There is no time mentioned in it as to if I was served the said notice 2 hours prior to my remand. That is not mentioned in the 47 notice.
Yes, that is my as earlier.
The time is very specific as per Mihi Rajesh Shah. If Lordship may allow, I may submit the Mihi Rajesh Shah order. And Lordship may be aware of the. And as per Vihan Kumar and Mihi Rajesh Shah, not only 47, 48 and as well as the provisions of arrest memo which exist in the BNSS has to be complied with due diligence.
Arrest memo, Mr. Borwan, no signature is there. Hmm? So arrest memo, if it is violated, this court has already held in many cases. If arrest memo, this is not complied with, then it is clearly a violation. Hmm. Hmm.
You know, other 47 of bail does not provide for a statement for time take for publication of the ground of arrest without participation. This court in police the ground of arrest is made to the arrestee in writing in one offense PRS, which is it is not be given the time of arrest but within a reasonable time thereafter for offences under all statutes, which period would be as has been laid down above this one.
Yes, exactly. The period which would have been laid down above in this order, which itself says that the above paragraph 16 in conclusion, paragraph 56, which clearly states that
2 hours, at least 2 hours.
yes, at least 2 hours. Clearly states.
Get to so much the prejudice one. What prejudice has been posed to?
No, that has been settled, Mr. That has been settled by this, I mean, prejudice concept is, taken away by this court. But this arrest memo itself, it is not there. On that ground only this goes. You can't help it, Mr. Borwa. What is there in the diary, you can't do anything. You are helpless. Okay, we'll pass down the order in this case. Take down the names. Because similar order has been passed by coordinate bench, this bench also. This has to be disposed of. Your submission is what? There is no prejudice. No, for 48 or 48 notice also, this, it says that 2 hours, at least 2 hours prior to the production. Well, we'll consider this and we'll dispose it of.
then 20, 23, and then 10.
এখন বেল এখন কি দুখানা বেল নেই? Yeah, which one is to be taken and taken?
This is item 20 is bail hearing, then motion.
10 is motion. 23 is a bail hearing. Okay.
This case, my lord, your lordship, 23 your lordship take.
Page 23.
No,
Oh, item,
23,
yes.
yeah. Page 16, my lord.
Mm.
Just let me have my lord some brief facts, my lord.
Yes.
This present petitioner is the wife of one of the, it is main accused, my lord, wife.
Mm.
And on 14, my lord, they have gone there, the police have gone and they have seized some materials, my lord, these narcotic drugs from the second floor. Second floor of the house, from the
Second plot of the house.
second floor, my lord. In the house, 2 floors are there, my lord. 1 floor we are living, my lord. I along with my husband.
Okay. Second floor they have seized it.
Yes. They found a second floor. I was not there. I was in my own floor, my lord. So at that time, they have arrested my lord on that day. You will kindly see page 17.
The first and second floor house belongs to you, but
No,
who?
only first, my lord. My father is there, my lord. Mother is also there.
Now, who stays in second floor?
That my Thurali.
Huh?
I stay in the first floor.
Now, who stays in the second floor?
That brother, my lord, who is also accused in this case.
Your brother stays in the second
The
floor.
second floor, and where from it was seized, my lord, and recovered.
Okay.
That was found on the second floor, my husband's brother, my lord. Not
Correct. I mean, your brother-in-law.
brother-in-law.
So, second floor, yeah, I mean, your brother-in-law stays from where the materials were seized.
Materials, yes.
I mean, these
Right.
narcotics.
And those persons were arrested, those who were found on the spot,
Hmm.
they have been arrested, my lord. Names are there, your lord, kindly say names.
Okay. Okay.
Number 1 is Jarina Begum, wife of my the brother-in-law,
Hmm.
second floor.
Hmm.
Number 2 is Rubul Ali, another person, my lord.
Hmm.
Mustafa, then 4, Inamul Hussain,
Hmm.
then Jahir, Ariful, Habibu.
So all these people were staying in the second floor.
No, rest persons are not, my lord, only my brother-in-law
Hmm.
and father-in-law, mother-in-law.
Now, your brother-in-law is Mumtul Ali.
Mamtul Ali,
So Mumtul Ali and his wife.
his wife Jarina,
So they were staying there, they were arrested.
arrested,
Then later on, Mumtul Ali in fact fled away.
fled away. And my husband also, according to that,
Yeah,
he is so-
your name is Aitul Ali.
yes, my husband name is
Your husband's name is Aitul Ali.
Aitul Ali.
So Aitul Ali and Mumtul fled away.
Yeah,
Then Jarina was arrested and you were also arrested.
no,
You were not arrested.
next day he was arrested.
Next day you were arrested.
That is my case, madam.
Next day you were arrested. Whether you were there at that point of time?
I am in my own floor, madam.
On floor, first
Yes,
floor.
It is very much there. My father-in-law, mother-in-law, they are also there in my floor, madam.
Okay.
Then kindly see, madam, seizure list, madam.
So was there any implication against you?
Madam, they are saying that since I am also involved in the case, this is how they have stated, they have filed an affidavit, madam.
Mhm.
And kindly see, madam, just I take the first page 27, then
Page-
I'll come to the affidavit, madam.
Page
Page
27.
27, forwarding report. It is 15 December, next day, madam, I was arrested.
Page 27.
No.
Yes.
Here are the kindly grounds of arrest number 3, my lord. The arrestee is a close family member of the prime accused and absconder Aitul Ali and Mamtul Ali. Yes, I do admit, my lord. I am the wife of.
But you have not read number two.
Number two, my
You
lord.
read number two.
No, no, I'm coming. Oh.
Number two, you see, arrestee's presence and
Arrested
role are revealed.
And role are revealed from the seizure of 86 opium and products of crime from her family house,
Mm.
not from me.
Not from you.
Yes. Now kindly come to seizure list, my lord. So far seizure list is concerned,
Mm.
what was from the house of Aitul, page 21,
Page
Type-
21.
type copy.
Yes.
Date and time of seizure, my lord, 15/12/2025 at 12:35 AM.
12:35 AM. Yes.
12:35 AM,
Yes.
PM, my lord, they have written, my lord.
Mm.
PM, it should be PM, my lord. It is,
PM, they have written.
it is,
this.
yes, PM in the original one. Then place of seizure, house of Aitul,
PM means then it's a daytime.
that time.
Yes.
They have arrested me,
Mm.
the next day they came and arrested me, my lord.
Mm.
Maybe on the basis of the co-accused statement, maybe, my lord.
Right.
House of Aitul, place
So,
of
so
seizure.
these are things
Arrested.
seized.
Now you'll have 3 numbers of checkbook of bank in the name of Aitul Ali, my husband's name.
Mm.
Then second one, passbook of Allahabad Bank, Aitul Ali.
Mm.
One
Checkbook.
checkbook of so-and-so, Aitul Ali.
Mm.
One checkbook of so-and-so, holder, Aitul Ali.
So no offensive particles were
So that is
seized
seized
from your position.
from my position.
Mm.
Now, my lord, what happened?
Mm.
These are the factual part.
Mm.
Now my case is, my lord, 48 notice. This is the only case in my lord. What they have stated, my lord, in the last time, yet I have nominated the Gauhati and the notice accordingly, notice was served to the Gauhati.
Page 40, where is that?
Yes, that you also will find that page in the affidavit, my lord. One more affidavit page, 38 to 48. No?
So your case is 48, section 48.
Yes, section 48.
So,
Also marriage also, my lord, just I have shown.
no,
you.
no, factual matter, I think you
Yes.
have clarified.
Yes.
Now affidavit,
Affidavit filed by
filed
the objection, you also find from page 38.
yes, yes, page 38.
Yeah,
Mhm.
your lordship will find paragraph 3, my lord.
Paragraph 3.
3, page 39. That after the accused were arrested, the remaining family members of the accused absconded, and no one from the family were found to serve the notice under section 48. The accused was asked as to whom she would nominate to receive the notice. Then she stated that Wasif Sheikia, who is the village Gaubura, as well as their co-villager and neighbor, could be served the notice under section 48. On being nominated by the accused, the notice under section 48 containing the grounds of arrest was duly served upon the Wasif Sheikia, so and so. It is to be mentioned here that law mandates, all right, madam. If it is, if I have nominated, I have nothing to say, madam. Now, whether nomination, how? It must be in writing, or it must be in orally, my lord. So they have stated that this is, my lord. Then I come to my lord, your lordship, kindly see paragraph 7. The present accused petitioner, Narjina Begum, is the wife of prime accused Aitul Ali. Paragraph 7. Who is still absconding? As date of NBW proclamation everything issued, my lord. Now kindly come to our affidavit, the reply, my lord, we have given on that point, my lord. Page 45, sorry, that is the one word one. Yes, 49. 49, you will kindly see the affidavit in reply, that will be better.
Yes, page 50.
Huh?
It starts from page 49.
Yes,
Mm.
49.
Yes.
An affidavit in reply filed with the petitioner in connection with the verification number so and so, that
Mm.
your lordship will find paragraph 5 onward, my lord.
Mm.
That the alleged petitioner begs to state that the allegation of a well-managed narcotics syndicate is wholly false, vague, and unsubstantiated. No material has been disclosed in the affidavit to show the conscious possession, active participation, or financial involvement in any illicit narcotic drugs. That the petitioner begs to state that the assertion of the recovery of commercial quantity from the possession of petitioner is categorically denied. The alleged recovery, if any, was not from the possession of the petitioner, but recovery was made from the house of Mamtul Ali, who resides on second floor, while the petitioner resides in the first floor. The affidavit in opposition is completely silent as to the manner of such is so and so. Petitioner begs to state the allegation is that the petitioner is financially well off. That also might be, I am the wife. Now coming to my lord, page 8, they have incorporated added another section 27A in the case, my lord. Petitioner begs to state that a reference to section 27A of the NDPS is misconceived and mechanical. There is no material placed before this court to prima facie attack the ingredients of financing illicit, that is harboring, etc. my lord. This section they have added as per their objection, my lord. Then you will kindly come to that paragraph 10, my lord, this is important, 10 and 11. The petitioner begs to state that in the affidavit, it is falsely stated that all family members were absconding. At the time of the arrest of the petitioner, her mother-in-law, father-in-law, that is the father and mother of Ayatollah, were very much present at home and they have never absconded. Moreover, the deponent as well as the mother of the petitioner who resides in the same village, which is only about 400 meters from the house of the petitioner. Therefore, the plea that no family members was available for service is incorrect and misleading. Your lordship got it, man. Next paragraph, my lord. That the petitioner begs to state that she never nominated the Gaubura to receive the notice under section so and so. The alleged nomination is an afterthought to justify non-compliance of the mandatory statutory safeguard. The investigation officer has not annexed any written nomination or acknowledgement signed by the petitioner. The petitioner further states that neither police asked her to nominate the Gaubura nor the petitioner told the police to serve the notice to the Gaubura. That the petitioner begs to state the service of notice upon the Gaubura without exhausting the option of serving the available family members. So all family members, my lord, that is all father, mother, and this petitioner's mother is also in the same village, my lord. The deponent who is also a niece of Ayatollah Ali, she is also going to reside in the nearby.
So your case is basically this, right?
Yes, my lord, basically.
Yes,
Then
Mr.
another affidavit, additional affidavit filed page 54.
Yeah, yes, what is that?
In this case, about nomination,
Hmm.
this deponent went to the jail and met, your lordship kindly
Where page?
paragraph 50, it starts from 54.
Yes,
Your lordship kindly see,
paragraph
4, your lordship kindly see.
400 meter, yes, that we have got.
Paragraph,
Hmm.
paragraph 5.
Hmm.
That the deponent begs to state that, your lordship kindly. In the last occasion, my lord, they have contended that I have nominated. After knowing about the submission of the learned additional PP through the counsel of the accused petitioner, the deponent, who is the niece of the petitioner's husband, went to jail to meet the petitioner to know as to whether she had nominated the Gaubura Wasif Shaikia to receive the notice issued under section so and so. But surprisingly, the petitioner categorically told the deponent that she had neither nominated nor any other person, neither nominated Gaubura nor any other person to receive the notice issued under section so and so, either already or in writing. Inasmuch as her family members, that is deponent, mother, mother-in-law, father-in-law, are very much available in the house from the date of arrest till date. The deponent further begs to state that the deponent herself was also available in her house, which is 400 meters away from the date of arrest till today. And as such, the question of nominating anyone, including Gaubura, does not arise. The deponent states that the police neither visited the house of the accused petitioner nor to the house of the deponent or to the house of her mother to serve the notice issued under section so at any time. And as the contention of the learned FPP is not at all based on facts, and the learned FPP might have been misled by the investigation officer about the service of the notice under section so and so, to the information of the deponent that after knowing the submission of the counsel of the petitioner, the police on their own made a false story to justify the illegality committed by them. And this may be substantiated from the case diary as to the date on which the statement of Gaubura was recorded and as to whether any authority on behalf of the accused petitioner in writing is available in the case diary with regard to the nomination of science. And paragraph 6 also important, my lord. Petitioner begs to state that after the arrest of the accused petitioner, the family members collected certified copies of all the relevant documents. And upon receipt of the same, it appears that the notice under section 48 in respect of some other accused also, my lord, served upon the said Gaubura. Here it may be stated that so far as Gubulari is concerned, the deponent states that he belonged to another district, Tamulpu, but the notice issued under section 48 shown to have been served to the aforesaid Gaubura. Gaubura, although
Yes.
the said Gubulari belongs to another village in another district, my lord, belongs to another different district. All this show that Wasif Shaikha, your lordship, the Gaubura of the petitioner village was utilized after knowing that the notice under section 30 has not been served either to the family members or relatives or friends. Here it may be clarified that the Wasif Sheikha is neither the relative nor the friends of the accused petitioner. Now, my lord, the same Wasif Sheikha was served notice in respect to another accused who belongs to different district. I have annexed it also. My lord, you will kindly see page 62, my lord. Oh, yes. 62. You will kindly see Wasif Sheikha in respect to Rubul Ali, my lord. Who is district, you will kindly see Bilay so PS Tamilpur district Tamilpur. Same Wasif Sheikha, he was served notice. All notices given to him. This show that something is there, my. This is my case, my lord. I think your lordship has got the point.
Yes, yes.
I
And what about the other case, this one?
for this one, I think 10, it is motion. He is also one of the arrested persons. Huh?
So what is your case?
Lordship, in my case, Lordship, I am an 18-year-old boy, and I am a pawn shop vendor by
How you are
occupation.
implicated?
Now, in the FIR, there is no allegation against me as to how and in what way I am connected to the instance, firstly. Secondly, Lordship, there is no sign of mine in the alleged seizure list, which contains the contraband, seizing of contraband. Thirdly, Lordship, the notice under section.
But anything has been recovered from you?
No,
No,
nothing.
then scissor list, why your signature will be there? No,
Nothing recovered. The implication, why am I connected to this case? There is no allegation within the content of the alleged FIR. Next, Lordship, and most importantly, section 47 notice does not consist my signature. That has not been served to me. I have annexed a certified copy of the section 47 notice in page 30 of my petition.
Page 30.
Yes, Annexure D, wherein the column read as signature of arrested accused has been left blank.
When were you arrested? You are being arrested?
On 14/12.
And where do you stay?
I stay in the Romia itself, wherein on that actually the background of the case is that I am a pawn shop vendor, and I went to the place of occurrence just to see the hue and cry going on there. And the police official, in order to in order to investigate, they took me to the police station, and thereafter they arrested me without even serving me a proper notice under section 47, and the said notice does not even consist any ground as to why I was arrested. 47 has not been served to me. Thereafter, Lordship, section 48 notice. Section 48 notice, page 32, as senior counsel sir already stated that this Wasif Saikia, in my case also, this Wasif Saikia has been made as to one nominated person, wherein I am nowhere aware as to who is this Wasif Saikia. And most importantly, Lordship, in the said notice, I have been introduced as the Gaupura. I have been, there it is written under the noting of, under the name of Wasif Saikia, it is written as, you are hereby informed that below named person who is your village head has been arrested in connection with the above reference case under the following laws.
Where is that?
Page 32, Lordship, wherein Wasif Saikia's name is written. Under this,
You are hereby informed.
that the below named person is your village head and has been arrested in connection with the above reference case. I am not the village head. This is not my identification. I am a pawn shop vendor by occupation. This notice even does not consist as to what is my role in the alleged case. Thereafter, Lordship, the arrest memo served to me, page 34, wherein in column 14, signature of arrested person obtained in vernacular language, there is no description as to if I was made aware of the content of the alleged seizure arrest memo. And that is very much mandated after the Mihir Rajesha judgment, which has made a clear observation that the arrest memo or any other particulars of the case has to be served in a language understood by the arrested person as to why I am arrested in this case. There is a clear violation of section 47, 48, as well as the arrest memo, 36 of the BNSS. All my constitutional right has been infringed. I have annexed a certified copy of my 47 and 48 notice. Further, Lordship, if a Lordship goes to the FIR itself is a ambiguous one. Because Lordship, in the FIR, which is at page 17, in the FIR, Lordship, in the FIR, the reference of the GDE number, General Diary Entry number given as 22 dated 13/11/2025. If it is 13/11, whereas the incident took place in 14/12, that means 1 month after the source information was received. And thereafter, most importantly, in page,
But does it make any difference?
there is a like the FIR itself is ambiguous.
No. This GD entry of 13/11/2025.
The most important part is in page 20.
No. Why this is? I mean, this is bad. 13/11/2025.
Lordship, as per the FIR, they have stated that a source information was received
Received when?
on 13/11, and the search carried out on 14/12. Why 1 month difference? There is a 1 month difference in the GD entry and occurrence of the alleged offense. And thereafter, in page 20, Lordship, wherein in the handwritten part, received by Rongia PS GD number 5. Here it is written as GD number 5, whereas the case happens to be GD number 22 in the first case. So the FIR itself is fictitious, creates a doubt as to the alleged occurrence of the offense. GD number is different.
What about the recovery? Recovery is also in doubt.
Recovery, that my lord, I'm not going into this because
No, you please tell. I mean, recovery is also in doubt.
Lordship, that is not in my arena, Lordship. I am here because, Lordship, my constitution.
Okay, your thing is 47, 48 in arrest memo, right? And you have shown those. I mean, why this 1 month time has taken? Because if the source information was received 1 month back, why so much of time was taken? That you are saying. Okay. Anything else? That's all. Yes, Mr. Parasar, you have. Yeah, you have a task. And you'll have to cross the bridge over River Kowai now. Yeah.
Total 45 small packet means 1 kg or 500 grams. This type of packets, total 45 packets, and 2 bundles of 25 kg, 17 kg, 2.8 kg. Plus what they got from the statement of the co-equal and all this, they got huge bundles. And in the house color, they make it small, 1 kg or half kg packet. So total 45 small packets, 1 kg or.
No, see, Mr. Parasar, I mean, there is no point wasting time. See, I'll tell you why. See, this about Caesar, about this thing, they don't have any complaints on that. Correct? They don't have any complaints on other things. They are only arguing whether these mandatory provisions are complied or not. Now, if you can satisfy that those are complied, the case finishes. And if you cannot satisfy, then they have a case. That's all. So like you just tell me from a first 1 point probably, I mean, at least before this court, this was not an issue earlier. I mean, see, now a person has been nominated, supposedly nominated. They are denying that this has been nominated. He has been nominated. So if a family member is not served and a nominated person is not served, they are saying this is bad. This is not as per the law. So now you'll have to argue that like, no, this Gaubura is a family member or Gaubura is somebody. So he is, I mean, so you'll have to satisfy that serving on the Gaubura will satisfy the mandate of the section. Yeah, first, hmm.
1512, the case diary, 1512, the DGA on this one.
Hmm.
At 900 hours, got the information, they will go to the house, at 1430 hours, 2:30, they went to the house. I interviewed the accused person, and I'm satisfied of her involvement in the narcotic drugs, right? And on being asked, now the accused, when arrested, remaining family members of the accused are not excluded, and no one from the family members were found in the house at present because of the notice served to the government. And regarding this one, this 1512 at 1430 hours.
No, no, yes, Gaubura also serving on the Gaubura is not disputed. No, it's not disputed.
Section 48, on being nominated by the accused person, this is the part of the diary. Because I am not going by any story. But senior malak, I am going by the whatever materials in the CD. And CD case diary malak on 1512 at 1430 2:30 hours malak, when they want the nomination regarding nomination, this is the entry. Now regarding that malak, statement of the Gaubura also subsequently taken.
Yes.
Statement of the Gaubura and another person also with the witness, the same. Statement of the Gaubura, it was taken subsequently, like 28-1, maybe. Most, and I am student to Vakif Sheikha and the Gaubura of the India. So on 15/12/25, when Nazma Begum was arrested and family members could be found, he nominated me to receive the notice under section 48 BNSS. When I received the notice, I went her to residence to give the notice to the family member. However, no family member to the accused could be found, and thus I could not serve the notice to her family member. Another person, Ritu Haq, the same village. My name is Ritu Haq. I am the resident of the Media Work Factory. I also witnessed to the fact that the notice under section 48 BNSS was received by the Gaubura because none of the family members was present at the time. After the Gaubura received the notice, he attempted to give it to the family members, however, none could found. That is the statement of one witness also. This is subsequently. Now, news quantity, drugs were there 86 kilo and 25,25,400 rupees. Total 25,25,000. Both the brothers, if that my husband may be involved and my brother-in-law. Our husband played away, our brother-in-law played away. Against both proclamation issued now 27 when 50,000 rupees also found 27 now 25,25,000 has been found. See, and why 27 will not come and 27.
No, that was seized from seized from where?
From the same building, from the house of the second floor. And this is a family business. They are making the ladies were making these small packets. They were making from the bundle. They are making these small packets, and the other person who is not the family member, the other persons, those persons are the peddlers. They are supposed to supply this to Manipur. I am not the name. One of the co-accused. His statement, I have been working for Mamtul and Aitul. They are running a business of drugs. Mamtul and Aitul and their family members have been doing this for long. Then I have joined them and become a part of their network. Recently, we have received a consignment of huge amount of opium for Manipur, for delivery to Manipur. I don't know who sold the opium. After receiving the consignment, the whole opium was shifted to the house of Mamtul. While we are planning to sell the opium to Rizalkam and Mamtul, the police First raid was at morning hours. And subsequently, those persons were found, they were killed. This is going on 87, the 5 crore, value of the drugs is 5 crore 16 lakhs approximately. 5 crore. And
So basically, say, I mean, your case is that this person was nominated by this lady, and that has come out from the nominated person's statement also. Statement also. So that is your case, right?
12:30, 2:30.
Hmm.
When they were, can you verify the statement of the Gauhati is also I have taken.
No, you show me the GD entry where, I mean, this. The wife of prime absconder means? Title. Okay.
I told them, they are brothers and they are. And first, it was the who was arrested, Regina is the wife of Mamdu.
Okay.
Well, only one thing, madam.
Yes.
Nomination, madam, that's for others. Nothing is there, madam. All have been nominated by this Wasif Shrika, madam.
But
Only Zarina,
but in your case, I mean, there is a GD entry available.
the entry of that year.
Mm.
Anyway, madam, I am not on that. My question, madam, 48, nomination to Wasif Shrika by all the accused, madam.
That
The others nomination are there or not, madam.
that. No, but like in your case, there is a GD entry.
That's, I'm not saying, madam, I'm not in
No,
GD.
whatever is there, I mean.
I question, madam, I was arrested next day, madam, not from the spot. Nothing required for me as per Caesar list also. This is my case, madam. I am simply, madam, had it been there, I could have been also taken, madam, along with others. That's this point.
But yeah, I mean, only thing is that your case, a GD entry is there specifically stating that you have nominated specific statement.
Madam, there,
And Gavura also confirmed that he has been nominated.
madam,
So
Gauhati-
as I mean, till this time.
Your work kind is what type of Gauga he is, madam. In
That
all the
one-
cases, madam, there he might have been set up by the knowledge to justify the illegality, madam. How can he be from another district, madam? And he is a Caesar witness also, madam. Can he be trusted, madam? He is Caesar witness also, madam. So if they manage someone, madam, to justify their illegality, madam, that is up to your lordship, madam. Another district
Hmm?
person.
Other states will now police are facing those problems, for starting for getting people. Because nowadays, retain has to be given. In this particular case, if other, some are arrested, some are fled away, so whom to give them? But, and there are witness also, that, yes, in my front, but what else police can do?
The Mr. Chaudhary, you can't also deny the fact that the problem they are facing.
Problem is that my
The
only-
problem they are facing. No,
Madam,
no, No,
My,
no,
only one,
No,
my mother is there.
Not,
Another house.
not as a senior lawyer, but as a citizen also, you can't
No,
deny that
I-
like there's a
there-
problem they're facing.
But my one is the lady, they all available, my lord. All oath we have taken straight. My mother was there.
No,
My
those things are
My
there.
two minor children, they are with my mother-in-law. If they absconded with those minor children, they are very much there till today, from the day till today, my lord.
No, only thing is that now court has to decide whether this serving of notice to the Gauhati
Yes.
can be termed as can be termed as complied under section 50.
Provided anything is there in writing or anything there, there must be something. my lord.
No, there is a GD entry.
That is,
that cannot be.
GD entry, all right, my lord, GD entry, that they have made it their works, my
No,
lord.
but I mean that, I mean.
Not on merit also, my lord.
On the face of it.
On merit also, so far I am concerned. Nothing seized from me. I was not there. Next day I was arrested. Only co-accused say something that your lordship to punching is
But
there.
co-accused is somebody like who stayed in your house and they
No,
are your
Other
relatives.
persons are there.
They are
Only one
relatives.
person arrested who is residing in the second floor, madam, wife of Mantulan. Others are outsider, madam.
And one peddler who has also.
Peddlers, madam, in the second floor, madam. Mike,
Eh,
I was not there, madam.
Anyways, I'll consider your this thing. I'll pass the order.
Had I been there,
And what
madam-
about the other thing?
If I can verify that tomorrow, or I have to check, regarding diary.
He wants some time to check it. No, not today. Not today. Let him check only, let him check. I mean, then let him be satisfied. I mean, otherwise you have given those documents. You have already given those documents. We are sure about this. So only thing is that he
Only
needs
there
to.
to see whether nomination is there or not, madam. Just like Mike, and whether that is there or not, madam. I think that is to be seen, madam. If in other case it is not there, mine also, I think I lost. I was because my husband and my brother-in-law.
No, Mr. Chaudhary, in your case, the problem is that, problem for you is that this GD entry is there, specifically written there.
No, GD entry is there, madam. The person whose statement your lordship, my lawyer is mentioning, madam. His character, his nature of that also to be seen, madam. Because he is the person.
No, those things will be seen in the trial.
You also to see whether it is there in the CD, my lord, about other persons.
But those things can be considered later on also. But at this stage, whether this court can go into all those things.
So merit also, madam, the lady, one lady, my lord, nothing, Caesar lordship is seen. Nothing from me, my lord.
Yeah, from her, nothing.
Yes, nothing.
But
Then-
from only thing is that from
even
the house.
Leaving aside 48, madam, otherwise also, madam, I am entitled in my.
Okay, I will consider it. This item number 10. Let the matter be listed tomorrow, huh? Item number 10. And this matter, it may take little bit of time, Mr. Chaudhary, to write this. I mean,
Anyway, madam,
because you have raised another thing that has to be tackled. But earlier we were writing simple 48 these notices.
my merit
Now you
I
have
had a
raised.
case on merit also, madam.
So now you have raised another thing.
No,
So
it is a fact, man.
so-
I think nobody can deny Caesar list is
No,
there.
I understand.
My arrest is next day.
No, what I'm saying is that so court has to also give time to
Well,
that.
my lord, that is absolutely.
So maybe.
Or,
Yes.
No, tomorrow, yours is tomorrow. Might I think further,
No, further needs.
not required.
Your senior has done whatever he needs to be done. Why you are insisting again to come him to the court?
Obliged to us. Obliged.
Well, I'll pass the order. I'll consider it, Mr.
Minor.
Chaudhary.
Two minor children, my lord.
You consider.
4 years and 7 years.
CD contact like CD will require, no? Kilometer is more. No, তিনটা কথা অক্সিবল হয়েছিল পাঁচটা মানুষ না Hearing কি আছে নাকি আজকে? তিনটা আছে। মানুষগুলো আছে নাকি? মানুষগুলো আছে? আচ্ছা। এটা এখানে তিনটা বাজার কমন হবে কেন ঠিক না? তোরা মানে ল্যাপটপ তো তোরা রাখা নেই ই করিয়েছে। Yes.
Milord,
Hmm?
I am on interim.
So you go and appear within 10 days.
Yes,
Hmm? Within 10 days, your interim will be extended.
yes.
Then you appear. Heard Mr.
A. Rahman.
A. Rahman, the learned counsel appearing for the accused applicant. Also heard Mr. K. Parasar, the learned APP for the state. This is an application you write, huh? Application you write, then you write that the learned APP submits the charge sheet in the instant case has already been submitted.
Right.
23. In view of the aforesaid submission, it is directed that the interim order, interim protection granted to the granted to the accused applicant by order dated 6/11/2025 is extended till extended till 24th.
24.
24th. Before that, you
Yes, yes.
extended till 24th of February. February 2026, before which date the accused applicant shall appear before the learned trial court and seek appropriate relief if so advises. In view of the aforesaid, the instant AB application is closed and disposed of.
Develop.
What is the offense?
My lord, search sheet has been submitted under section 302/201. This is a case of, my lord, 2014. Search sheet submitted in the year 2025 February. 2018, my lord, I applied for the, my lord, passport. Then, my lord, for the police verification, my lord, I went to the police station. Then, my lord, this PAN card, voter card, etc., these were all kept. Then again in the year, my lord, 2022, my lord, I went to the police station. Then also, my lord, nothing was, now, my lord, showing me as absconder. Search sheet has been submitted.
Yeah.
Lordship will kindly look at the, my lord, the last order passed by this honorable court, my lord. Here it is condition, my lord, that the accused petitioner shall cooperate with the trial. My only anxiety is that, my lord, now first I have to appear before the CGM, my lord. Then the case will be committed to the trial court sessions court as 302 is there, my lord. So I will face the trial, my lord.
Next day, sometime. Heard Mr. B.M. Chaudhary, Dana Counsel appeared for the accused applicant, also Mr. K.K. Parasar, on the prayer of learned K.K. Parasar, let the matter be fixed on 17th?
17.
17th.
Interim should be continued.
Interim order so passed earlier shall continue till the next date of the stay.
Oblige, Lord.
41.
May it pleases your lordship, my lord.
Hmm.
My lord, here the affair is at page 58, my lord. My lord, the main basis of the affair is of the two inquiry reports. Lordship, the affair reads like that, my lord. With reference to the above, I directed to request you kindly to raise a regular case against Dr. Singh, the then executive engineer Nalbari, division and presently posted as superintendent engineer PSC Hailakandi Circle, reached as per the preliminary inquiry report submitted dated 28/4/2022 by the Deputy Commissioner Nalbari regarding misappropriation of government money by so-and-so in the form of payment of all bills for construction of IHHL, individual household letting.
You are
under-
working as what? You are working as what?
I'm presently working as well as superintendent engineer PHC,
Hmm.
Hailakandi, my lord, Circle.
Hmm.
At the relevant time, my lord, I was working as executive engineer, PHC Nalbari, my lord. My lord, and based on the fact finding of the inquiry report of DP dated 21/2/2023, these two report, my lord, will also find at page 62.
Yes, yes,
And-
I mean, what he has appeared and
Yes, my lord.
he's
yes,
cooperating.
Yes, my lord.
So anything,
already-
anything you, I mean, do you have any objection to this? No, that will record what your objection.
Yes,
No, now, see, now only thing is that, I mean, interim was there, he's cooperating with the investigation. Is there any violation? Is he not, there is nothing like that. So let him go and like cooperate with your investigation. What purpose will be served keeping him inside? Hmm?
Right.
Heard Mr. BK Das, the learned counsel appearing for the accused applicant, also heard Mr. PJ Bourbon. Mr. PJ Bourbon, the learned, you are appearing as additional special PP, CM Vigilance. CM Vigilance for the CM Vigilance, full stop. This is an application under, you just write application under so and so. The case of the petitioner is that although on an earlier occasion, he has been dismissed from service after a disciplinary proceeding, the said proceeding has already been interfered by this court and court, and liberty was given to the disciplinary authority to proceed with a fresh disciplinary proceeding within a period of 6 months from the date of passing of the aforesaid order. Order. Thereafter another proceeding started.
Yeah, well, they started, but that has been stayed by this honorable. court.
Thereafter, a fresh inquiry was, fresh disciplinary,
Purpose was issued, my lord.
fresh disciplinary proceeding was started against the accused applicant, which was challenged by the accused applicant before the Gauhati High Court,
Yes.
and the same was stayed by order dated.
My lord, 6/8/2025.
The same was stayed by order dated 6/8/2025.
My lord, it passed in WPC number 4114414.
Please write, passed in WPC number so and so.
4414/2025, my lord, case 54.
25. Full stop. Full stop. The learned counsel appearing for the Mr. BK Das, the learned counsel appearing for the accused applicant submits that that the disciplinary, since the disciplinary proceeding has already been stayed and the same is seized by this court, and the same is pending before this court. He should be, the accused applicant should be allowed to go on bail, go on pre-arrest bail at this stage, full stop. He further submits that in You are going to retire in two
By,
thousand six?
by this month, 28th of.
It should have been 2006 probably, 2026.
26, it's a wrongly written,
Mm.
Lord.
Then he submits that the accused applicant is going to be is scheduled to be retired on February 2026.
Yes.
26. And and in terms of the interim order dated 21/1/2026, the accused applicant has already appeared before the investigating authority
And cooperate with them.
and cooperating with the investigating authority. In view of the aforesaid, he submits that the interim order so passed earlier on 21/1/2026
Maybe made.
should be made absolute. Should be made absolute, full stop. However, the learned special, additional special PP, CMB Vigilance has objected to the aforesaid prayer, citing incriminating materials against him in the case diary, full stop. This court, after considering the submissions made by the counsel appearing for the respective parties, as well as on perusal of, this is the case diary, right? On perusal of the case diary, which is produced before this court, is of the considered opinion that the interim order so passed on 21/1/2026 should be made absolute in same terms and conditions as prescribed in the aforesaid order. Full stop. In view of the aforesaid directions, the instant pre-arrest bail application is made absolute and made allowed by making the same absolute and disposed of. Case diary.
Deeply obliged.
I'll just rise for 5 minutes, something.
Here, my lord, with all respect, my lord. There are two cases, my lord. The first affair is, my lord, that occurs at, my lord, with all respect, my lord, page 13, my lord.
Page 13.
13, my lord. If it is read in totality, my lord, the same political party, my lord, fight between two groups, my lord, there is a cross case also, my lord. And if it is read in totality, my lord, one part comes out, my lord, there is an allegation of giver's heart being called in the hand, my lord. That occurs at the next page, my lord. If I turn the page 14, my lord. First paragraph, my lord. May I read, my lord?
Yes.
Before my husband and Ahmed Sahil could defend themselves, the accused persons repeatedly attacked my husband. One of the accused inflicted a severe blow on my husband's right hand with a sharp dagger. Have I made my position clear, my lord? Even then, my lord, assuming there is grievous hurt, my lord, the earlier 326, and now, my lord, if I'm not mistaken, my lord, the ingredients of, my lord, with all respect, my lord, 189, I'm sorry, my lord, 181, no? 181 would be fulfilled, my lord. Earlier 326 IPC, now 118, my lord. And the cross case that occurs at, my lord, case 20, my lord. Same Congress office, my lord. Exactly similar sort of allegations, my lord. My lord, one party lodging the case against the other. Here also allegations of grievous hurt. 118(2) is there, my lord. Now, my lord, with all respect, my lord, initially we moved Court of Sessions, my lord. Court of Sessions granted me the privilege of ad interim pre-arrest bail, my lord. Thereafter, my lord, it was upon perusal of case diary, without discussing the medical report, my lord, it was cancelled because the reason, my lord, there are allegations that, my lord, with all respect, my lord, some, my lord, tampering with evidence has taken place, my lord. And that order is that, my lord, page 26, my lord. It begins at 25, my lord. This is the order by which the ad interim pre-arrest bail granted by the Court of Sessions was rejected, my lord. Page 26, third paragraph, my lord. I have gone through the materials available in the case diary, considering the nature of offence and the materials of CD, as well as the objection filed by the objectors. The order dated so-and-so by which interim bail has been granted to accused so-and-so, so-and-so, so-and-so.
Where is that allegation of temper or something?
My lord, the objection, my lord. Now when they have filed one thing, my lord. They have filed an objection here in the Gauhati, before your lordships, my lord. When we have filed a pre-arrest bail application, there these allegations are there, my lord. And that occurs at, my lord, with all respect, my lord, they have filed a written objection, my lord.
Written objection here in this case?
Yes, my lord. Huh? It could be. Oh, I'm sorry, my lord. This written objection was filed in the Court of Sessions, my lord. I'm sorry, my lord, not before your lordships, my lord.
That copy is there.
Yes, my lord. May I read it and place it before your lordships, my lord?
Yes.
May I read? With all respect and forbearance, my lord. That occurs at paragraph 5 of their objection before the Court of Sessions, my lord. That I informant beg to submit that after reaching at the Karimganj Civil Hospital, there were two parts, my lord. Both I'm reading out, my lord. Civil Hospital, the doctors attended, but the bleeding could not be controlled. And as such, the doctors of Karimganj Civil Hospital had immediately referred the patient to Silchar Medical College Hospital. In the Silchar Medical College and Hospital, the patient was operated and was diagnosed with fracture, but the patient was also needed plastic surgery. And as there was no facility for plastic surgery at Silchar Medical College Hospital, so that the patient was released on request by the patient's side. Have I made my position clear, my lord? Hand injury and release on at the request of, my lord, with all respect, my lord. So meaning thereby, my lord, grievous injury is doubtful, my lord, one part. Secondly, my lord, why it was rejected? The learned Court of Sessions never considered the injury, but only, my lord, the allegations that we tampered. Para 9, my lord, of the same application, my lord, praying for rejection of the interim bail granted at a Court of Sessions, my lord. May I read, my lord?
Yes.
That the informant beg to submit that soon after the protection order passed by the learned court, the accused persons are threatening the husband of the informant and Ahmed Sahil, that if they get bail, then before the next assembly election, they will eliminate both Ahmed Sahil and the husband of the informant. If this is true, my lord, then, my lord, they are to lodge an FIR, my lord, merely stating in an application, objecting, making the bail absolute is not good enough, my lord. If there are threats, my lord, they are to inform to police. And non-informing itself is an offense, my lord, under the BNS, my lord. Have I made my position clear, my lord? And learned magistrate, my lord, sorry, my lord, I'm sorry, my lord. The learned Court of Sessions rejected it. Well, in that order, he did not say anything regarding, my lord, with all respect, my lord, the injuries, because injuries are there in the hand, my lord. Have I made my position clear, my lord? But only regarding this part, my lord, that some threats were provided. Providing threats, my lord, possibly is not enough in the application, objecting for making the bail absolute. But there has to be a police complaint, my lord, who needs to be attached, my lord. Those are missing, my lord. This is my case, my lord.
Yes. We'll call for the CD.
Sir, can I just say one thing, my lord? Assuming, my lord, with all respect, my lord, assuming the injuries are grievous, my lord, even hand, my lord, and he was taken out from the apparent, my lord, their averments, my lord. On their request, my lord, with all respect, my lord, the patient was taken out, meaning thereby he was out of danger, my lord. And assuming,
There can be another meaning also that they want to take him to a different place, in a better place.
my lord, in that event, my lord, it has to be a government hospital, my lord, from a private hospital, treated and taken out. And political rivalry between both the parties, my lord. Of course, this is my.
Yeah,
prayer,
we'll consider this,
My lord.
let case there come.
Okay, can it be like this, my lord, with all respect, my lord? My lord, the medical report should be there in the case diary, my lord.
Yes, yes. Yes.
And another part, my lord, not from a private hospital, but from a government hospital, my lord. Private, every money manipulation, in the hand, my lord. And my lord, another, of course, this is my prayer, my lord, I may be wrong, my lord. Whether the injuries are there in the hand only. Only in
That also, the medical report will
Yes,
disclose
yes,
that.
yes.
Heard Mr. B.K. Mahajan, the learned counsel appearing for the accused. Sir, we are calling for CD. What do you want now? GT entry? That will come with the case diary. Mr. B.K. Mahajan, learned counsel for the accused applicant. Also heard Mr. K.K. Parasar, the learned APP for the state. Your name? PL Oscar for the informant. For the appeared for the informant, full stop. This is an application that he this is an application so and so. The allegation relates to causing grievous hurt grievous hurt by the accused applicant on the body of the husband, your husband.
My lord.
Informants? Who is the informant?
Informant's husband, my lord. Injury on husband's hand, my lord.
Grievous injury on the informant's husband. Full stop. Call for the CD, including the medical report. Including the medical report.
Well,
Let the
if
matter
possible, my lord, date may be.
Let the matter be fixed on 25th. 25th.
My lord, can it be little bit prepon, my lord, outside, my lord,
25th. Before that, it will be difficult, Mr. Mohan.
if possible, ma'am.
We can post it on 23rd.
My lord, my lord. Highly
23rd, 23rd.
Highly obliged. Obliged.
Believing taking. Believing.
Look, the argument or respondents are incomplete, my lord.
Hmm?
Supposed to fight, they have argument, my lord. Respondents have.
Who is appearing for us? Okay, this case.
Yes, my lord.
This case we'll post it on some other date.
Yes.
He also not there.
Short date may be given.
Mr.
A Gohai.
Eh?
A Gohai.
A Gohai. Mr. A Gohai appears for the petitioner, however, none appeared for the respondent when the matter was called for. Let the matter be fixed. Twenty-six, it will be difficult. And this bench will be not available for some time in the March. Okay, we are fixing on 26th of this month. Let's see if you can do it.
Obliged.
16.
May I please, your lordship?
Yes.
So the record was called from the trial court as per the office note dated 10/2/26. Half of the record has come, but half of the record has not been received.
Heard Mr. B. Chaudhary, the learned counsel appearing for the petitioner. Also heard MSP Gupta, the learned counsel appearing on behalf of respondent number 2. it is seen from the office note dated 10/2/2026 that the complete case record, complete case record of criminal appeal number 174217 has not been received by the section, by the office, by the registry till date. Let the matter be fixed on let the matter be fixed in the first week of March. No, first week of March.
BP of next.
So we have posted in some other date. Mr. P, you just write, Mr. P Nayak, the additional advocate general, is present for the respondents.
My lord, respondent number 2 has appeared today, my lord. My lord, can it be in the second week of March, my lord?
Okay. Heard MS N. Thakuria, the learned NS Thakuria, the learned counsel appearing for the petitioner. Also heard Mr. Ebu Sumantari, the learned counsel appearing for respondent number 2. The learned counsel appearing for respondent number 2 has submitted that he has filed wakalat number today. Has submitted that he has filed wakalat number. He has filed the wakalat number today only, and therefore for some more time. You'll file this thing. You will file any objection to this? It's not required. It's not required. File wakalat number today and praise for the listing of the matter in the second week of March, which was not objected by the counsel appearing for the petitioner. Let the matter be listed in the second week of March.
Order.
May I please, Your Honor?
Yes.
My lord, this IA file, my lord, in the main place. Very limited PR in this IA. That matter may be hard with dispense of deposit of 20%, my lord, of compensation. And as well, lordship, what the court below did not impose any condition of 20%. So far, an Act 148 as well as lordship section 143A is concerned. And that is also not mandatory requirement. May impose. But my lord, here, my lord, the so far office note dated, my lord, 6/2/2026. The LCR of CR case number has also not been received. So after
The records of CR case number is also available.
Where?
The file itself.
Which file?
CR is where page number 36 is a part of CR case number. Has the complaint petition as well. So back from page number 30.
it is relating to the appeal.
But it also contains the LCR of.
Our office note lordship 6/2/2026 says that LCR pertaining to CR number 888/2018 has yet not been received. When learned friends saying about criminal appeal, these are all record criminal appeal.
That file is highly under section 403 of DNSS.
No, notice has yet not issued.
Lordship, this I.
Records are there, records are there. Records are there, but I mean, we'll post it some other day. We'll post it some other day. We are not got, we're not passing any order today.
Lordship, in this, I, my lord, notice may go, my lord, this first day listed, my lord. Let them file objections with. These are. Because lordship, no, that is not mandatory requirement, no. Court below, did not impose such condition as per.
You file an objection, bring it on record.
Yes.
No, you are saying that it's not maintainable. Why?
So. Yes, I'm not against the judgment. No, you file objection, then you submit. Without pleading, how you can submit? This is the first day, notice has yet not issued. And after issuing notice by this small court, then you will ample opportunity to file objection and heard them. No, it is against judgment. It is not against judgment. It is an order. Coordinate bench also can pass order subsequent. I am not against the judgment or final order. 403 clearly saying against judgment or final order not maintained. I am not against judgment. This is dispense with. Only with limited period matter may be hard to dispense with the deposit. This is not mandatory. That is not mandatory requirement. And learned appellate court did not impose any condition.
That was imposed 20%, then the trial court doesn't apply here. The trial court has upheld the statement, upheld the judgment. This lordship, give me 5 minutes. 5 minutes is enough, lordship.
Yes.
Lordship, I may leave.
And let me heard my part first, my lord. So far, my lord, so far.
C is arguing on the maintainability, so let us submit what is there.
Genesis.
403, Genesis.
Lordship 403 says, my lord, save as otherwise provided by this section.
Now, what is your prayer in this?
Or by any other law for the time being in force, no court when it has signed its judgment or final order disposing of a case. The case is not disposed of, my lord. Only order passed that subject to payment 20% of compensation amount. And therefore so modification, my lord. This is not final order. And so far section 148 of an act, this is amendment provision. This is only applied in appellate court, not in the divisional court. And in divisional court, this cannot be implied. This is the issue, my lord. Lordship 148, so far amendment section of an act is concerned, it is only applicable in appellate court. May I read, my lord, 148? Power of appellate court to order payment pending appeal against conviction, notwithstanding anything contained in the Code of Criminal Procedure 1973, in an appeal by the drawer against conviction under section 138, the appellate court may order the appellant to deposit such sum which shall be minimum of 20% of the fine or compensation awarded by the trial court. Now, in this aspect, this section is not applicable in revision petition. Now, I relied upon, my lord, one judgment passed by one Supreme Court in Jumbo Bhandari case. Here clearly says, even did not deposit, the High Court can hurt them. Very clearly says. And thereafter.
But you have filed this I-1 403.
Yeah. This paragraph, my lord, paragraph 12, saying, my lord.
No, 403, you tell me, you convince me the 403, how can you file this?
No, 403.
See, you are seeking for seeking for a relief, right? Relief by way of depositing 20% of the compensation amount. So that will amount to a different thing.
And
And because, my lord, here for modification of order dated 3/6/2025.
See, 403 says, save as otherwise provided by this Sanhita or any other law time being enforced, no court, when it has signed its judgment or final
Or
order,
final order.
judgment or final order,
Disposing.
disposing of a case, shall alter or review the same except to correct a clerical or arithmetic error.
Exactly.
Now, it will be, if your 20% is allowed, then it will be kind of reviewing the order,
No, it is
earlier
not-
order.
That is, my lord, that is not the final order. This section says.
So which,
draft-
or
draft or final order.
where is this order?
Order says, page, my lord, page 9, my lord. Here, my
Page
lord,
9.
Let me, page 9, and here, my lord, a prima facie case made out under paragraph 4. The code clearly mentioned regarding, my lord, A.C. Narayan full bail judgment, saying that if the power of attorney does not have any knowledge, he cannot adduce evidence. And there is no any assertion in the complaint, and it is covered case, full bail decision, that is also quoted. And paragraph 9, thereafter, the coordinating branch observed that it appears that there is a prima facie case to grant stay. So if there is a prima facie case, why I will pay the deposit 20%? Because case itself not maintainable.
Not, Mr. Bhuya, not,
Lost-
it's
and-
not that, it's not that.
And
it's not
now
that.
under paragraph 12, 12 says.
No,
that-
there is a order of this coordinate bands asking you to deposit this 20% amount,
But
20% amount. Now you are coming for, coming for
Limited
dispensing with this.
limited
And
period
whether
matter
whether this can be filed under 403.
Now, my
Hmm.
lord, here Jumbo Bhandari case saying, even though High Court can
Hmm.
heard the matter without deposit of 20%.
No, that's a different thing. That's a different thing.
And so far, this section says only against final judgment, I cannot file this modification. And it is, my lord, interpreted order and coordinate branch also can pass order. This court is not powerless. If some other court pass order, that doesn't mean that this court is powerless. This
No,
court also, right? to
There's no
say.
question of powerless.
So, my lord, let them file objection, my lord. If not maintainable, then reject, my lord.
If I may allow.
No, you file an objection.
If there is not maintainable, I
No, I'm not convinced with your argument. You file an objection, you file a written objection to the IO. I'll issue a notice. You file it, bring it on record. Then we'll hear it.
I'll this right over.
five minutes, 5 minutes, Lord.
Yes, 5 minutes I'll allow. Yes. Mhm. The 403, we are aware, we have seen it, yes.
But in our case, 20% is already, 20% deposit is already imposed.
So he's seeking for he's seeking that, he's praying that this 20% which has been imposed, that should be dispensed with. That is his prayer.
In case where the 20% deposit has not been asked by the Honorable High Court or the Appellate Court, in that case, before imposing of 20%, the courts may directly dispose of the matter after.
No, you argue on the maintainability. Don't argue on that. You argue on the maintainability and convince this court that this is not maintainable. Correct? So you argued on that first. So convince the court that this is not maintainable and why it is not maintainable. It's not petition for amendment. It's not amendment. It's not for amendment. Hmm. 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 Hmm.
Section apply only when there is any alteration or amendment to be done. It's not for dispensing of 20%.
Now, is there any word, is there any word which is, word that you have used, alter, amendment in 403?
Yes, then it is.
What is the language? What is the language?
Shall, the word shall is used.
Yes, I understand that.
Yes. And this section is asking for final not for interim orders. This section specifically says for signing of final judgment or final order. How is interim order passed covered under this section? And I would also like to point this case, the order that we have shown in page number 9. The stay was granted in the absence of the respondents. And he failed to take steps.
Don't argue these things, madam. Don't argue these things in this petition. Yes, he argued on that.
It's clear on page number 7, if I may read. Under the above facts and.
No, see, I mean, you come to page 11. Para 12. Meanwhile, the operation of the impugned judgment and order of the aforementioned cases are stayed until further orders, subject to condition that petitioner deposits 20% of the compensation amount before the trial court. Correct?
My lord, 1 month imprisonment, my lord, and compensation amount 3 lakhs. And both the court, my lord, below committed glaring mistake that overlooked the decision of AC Narayan case. AC Narayan case clearly covered this case because one power of attorney filed a case who doesn't have any knowledge and he cannot adduce the evidence. This is the case. And that on that point, my learned friend, nothing submitted. He complained, and this Jamba Bharati case says.
This 7 months.
No,
Violation. After being violated.
Jumbo Bharati case.
No, Mr. Bhuya. Why you have not deposited this 20%?
No, because my lord.
No, why you have not deposited this
because, my lord,
20%?
it is admitted fact only 14,000 liable.
Whatever there was a
But
judicial
therefore,
order, there was a
he will
judicial
be-
order
he
from
will
this
be-
court.
He will suffer.
There was a judicial order from this court.
Therefore, this.
Why you have not, you deposited there within 3 months?
My lord, for dispense of
Huh?
this.
Now you have come, when you have come? You have filed, you have filed when? You have filed in the 4th February.
And
No, you filed on 4th February.
my lord.
No, you tell me why 3 months period was not complied with?
I told my client that he's.
No, please don't go here and please don't go
he-
here and there. I mean, this application is not maintainable. I mean, you have been directed to pay this money within 3 months. You have not paid this money after 3 months. Now you are coming after 8 months and you are saying that let it be dispensed with. How can it be?
No, there is a provision, my lord.
What provision?
We can approach.
What you have been doing for
Because I am being
what you have been doing for last 5 months?
I am being prejudiced.
What you have been doing for last 5 months?
Case was.
Is there an explanation? You give, where is the explanation? You give me the explanation. Where is that?
My lord, matter may be hard, my lord.
No matter may be
any
hard.
other date.
No matter may be hard.
Any other date,
No matter may be hard.
any other date, then.
Now you are saying about any other day? No.
And another, my lord, judgment, one of Supreme Court says, my lord, in Rakesh Ranjan Srivastava case, my lord. Here also says that this 20%.
No, I
is
mean,
not mandatory requirement.
Mr. Bhuya, the specific question is that why you have not paid within 3 months? If you have not paid within 3 months, why you have not approached court earlier? And why you have come after 5 months now saying that like this should be dispensed with in order of this court? There is no explanation about the delay part. You have not explained why you have approached this court after 5 months.
My lord, my humble submission, but when there is a prima facie case, so what this order itself reveals, there is a prima facie.
There is
case.
no prima facie case.
Here, my lord, the order, my lord, page 11, paragraph 9, it clearly appeared.
We'll post it on,
Yes.
Next week, and you please come prepared and like convince me, and like convince about the delay. Heard Mr. K. Bhuya, the learned counsel appearing for the petitioner. Also heard P. Gupta, the learned counsel appearing for respondent number 2. Let the matter be fixed on 16th February, Monday you come.
For admission,
Monday you come.
for admission.
Yes, so no, it is an order, no? For order. 16, no 17.
Obliged, Lordship.
May some matters no, it is common also. Mr. Agarwal, which matter you have? 41. He is waiting for quite some time. Yesterday also the matter was there. Day before yesterday matter was there. What is to be done?
Not better is very short, man. Not can be disposed of, subject to his appearance, my lord, because without, it will not be proper to
The
take.
next Tuesday we'll fix it. Next Tuesday.
Tuesday, my lord, I'll be not there.
Not
On
there.
Thursday or 21st, Saturday, your lordship can take.
Thursday will fix.
That be Thursday.
Next Saturday court is open over. No?
Okay.
Huh? Next Saturday?
Next Saturday open.
Okay, first and third.
So
First and
21st,
third.
subject to your lordship's convenience, either 19th or 21st. 19th, then at 2 p.m. I think it will be better. So part
19 will fix.
19 at 2 p.m.
Okay, now if there are bail hearings, then this needs
that-
to be
no,
done.
no.
After the bail hearings. After the bail hearings will take.
No, anytime, my lord. I'll be available, my lord.
Yes, 19th. Mr. K. Agarwal, the
Because
learned-
the matter, my lord, here what happens in this case, my lord, that my lord, the session judge relied on a judgment which has been already set aside by the session judge to convict me, my lord. It was an appeal against accuser.
Oh.
So it can't be, my lord. On that short ground, it can be, my lord, remanded back and the matter can be heard by the session judge.
Okay, 19th will
Ah.
surely. Yeah.
On merit also, I have a case, but, my lord,
But this cannot be done. I
this
mean,
cannot be done, my lord, because
but which has already been set
already
aside.
set aside, it was remanded back. Thereafter, a judgment was, acquittal was passed.
Hmm.
Against that acquittal, my lord, order was, acquittal was set aside, relying on the judgment that has been already set aside by the. So that can't be done, my lord.
Okay.
That is a short question.
Yes. We'll try to dispose it of on 19th. Okay, Agarwal, you are Mr.
And every day.
ABD on behalf of? Okay, doctor. Let the matter be fixed on, so it's 19th, 19th.
34.
Which matter? No, which was the matter? 30, item number? 30. Okay. The 10th of March.
May I please, your lordship? 34, your lordship.
34.
That may be pass over, your lordship. I have some technical.
So on the prayer of Mr. N.N. Upadhyay, the learned counsel, appearing for the petitioner, let the matter be fixed. When?
March first week or second week?
In the first week of March.
Problem.
35.
Kindly, this matter may take any other day, Lordship. My senior
Okay, on the prayer of Mr.
Ayu Chaudhary.
I.U. Chaudhary, the learned counsel appearing for the appellant, let the matter be fixed in the first week of March.
Deeply obliged.
Only. Is there no? Okay. Have you checked the other one? So we have fixed it some other day, no? Tomorrow. That is not there. You'll have to do something. Hmm? You please do something on this. I mean, at least 47, 48 and 36. Otherwise, um, no, otherwise the court cannot go to the merits, no? I mean, only on the basis of technical ground. Because these are NDPS matters and all these things. All-